Good afternoon, good afternoon, good afternoon, amazing law nerd. It's time for the Kouri Richins case. It's technically trial day 14, but it's a jury instruction day, which means no jurors, lots of law. Grab a snack. There's a lot we need to go through with the jury instruction conference. It will probably have starts and stops to the day. We're just going to watch. I will explain what they are doing as they are doing it. You are going to hear phrases like Muji quite a lot. Emily, what's a Muji? A place to buy pens. No, I'm teasing. Model Utah Jury Instructions. MUJI. Different jurisdictions call their model jury instructions different things. You're going to hear them referring to the Mujis. The jury instructions get populated before trial starts on what's expected, and then they have to be curtailed to what evidence actually came in. You're going to see in the jury instruction set as they get populated, there's going to be an instruction for if the defendant testifies and if the defendant does not testify. And then at the end of trial, they go and pull certain things out. They go and line certain things out. They edit things, and they decide what is going to be in the final jury instructions and argue the law surrounding that. There's case law regarding jury instructions. They get modified by committee, and they are incredibly important. And we have covered at least one, if not more, appeals that are arguing the jury instructions, that the jury instruction itself is improper. And jury instructions can get changed and overturned, which can impact older cases or future cases for sure. And so the jury instructions are an incredibly important part, but the jury is out, and it's not always the most riveting. We'll make it fun, but it's not always the most riveting part of trial, but it is one of the most important parts of trial we get to see. And you get to see a little bit of the wrangling of the attorneys and them thinking on their feet and using the case law and the language of the instructions to argue over what goes in and what comes out. Because ultimately, the law that is explained to the jurors is how they decide the case. And that is incredibly important. The jurors come in off the street, off of their everyday lives. They get sat in a jury box for going on 4 weeks. And then at the end of 4 weeks, they're just like, here, decide. Murder? No murder. What do we think, everybody? And they're given that packet of jury instructions and are like, good luck, which to the US law nerds are like, yeah, that's how we do it. To the international law nerds, that is a wild concept. You get a bunch of paper, and it's like, here's how to decide if laws were violated or not. Do your best. Oh, and if you ask us any questions, we can't answer most of them. Make good choices. It's wild. But that is why there is so much emphasis and time taken on the jury instructions. And court started a little bit late today, so I'm always happy for a little bit of a rolling start. Look, I love to relay. We get a little bit of a rolling start. It's fantastic. So we're going to just head into court, watch it all unfold. We don't have a ton of Zoom room, so we don't have a lot of 1.25 speed. Grab a snack. We're going to just sit and see what happens. We'll explain what comes up and answer some colors. Somebody was complimenting the green. There we go. Answer some questions. This is why I shouldn't read chat, because at the end of 4 weeks of trial, my brain just grabs onto random words and spits them out in place of other words. Adcomet said off the street like stray dogs in a courtroom. That's not how I think of that analogy, and I'll tell you why real quick. Indulge me for a second. How many of you did band of any kind in school? Marching band? Any kind of band? How much band have we done? Those of you who have done band or have been band adjacent will understand this. My high school band director, Mr. A. This is where this started. Law nerds, it's like therapy this afternoon. This is where this started with Mr. A, my band director. We never called him by his last name. It was just Mr. A, like from the A team. It was just Mr. A. Also, his name was Al Adams, so it made sense. Mr. A had a huge impact in my life, as band directors do. Band directors are amazing. But Mr. A started teaching us in like elementary school band, and then junior high, and then high school marching band. So by the time you got to high school, you have been in band with Mr. A for what feels like your entire life, right? Because you've started in like 4th grade, 3rd grade, or whatever. And Mr. A, when we were struggling, especially in junior high, when we were struggling, would look at us and be like, what you're doing here is special. Oh, Emily, you're all emo. Why are we telling this story? I don't know. It's just happening in real time. What you're doing here is special. You can't just pull any kid off the street, put an instrument in his hand, and tell him to play. This is different. This takes time. This is hard. This takes dedication. This is frustrating. But when we get out on that field under the lights, it's worth it. And it still sticks with me. So when I'm talking about you just grab people off the street, stick them in a jury box, I'm thinking of my band director. I don't know why I'm all emo about this. I have a senior in high school. I apologize for nothing. And so when I think about my band director sitting there and telling us, like, this is different, this is special, this is hard, this takes effort, this takes work, this takes time. That analogy just sticks with me because it's something that I also tell my kids, right? Things worth doing are difficult. Things worth doing take time. Things worth doing are not instantaneous, immediate. And I think it hits me more now than it did then because that felt really true. It's easy that feels true in like 1993. Like, it's easy to say this is hard. It takes time. You need to practice. You need to put in the hours. But in 2026, that lesson feels so different than it did in the 90s because things now are so immediate and it feels like there's so much pressure for nothing to be slow and nothing to take time and nothing to have the work and the effort of iterating and building and knowing that the first time it's not going to be good and the second time it's not going to be good and the 30th time it might not be good, but eventually it's going to be good, and it takes time. And there's not a lot of things right now where it feels like we're allowed to just take time and to give things the time that they need to get them done or get them done right. It feels like we are pushed to do things faster than is natural. Emily, really? Yeah, it does. It feels like things don't get the time that they need to be thought through, to be planned, to be evaluated, and to get it wrong. Like the first time, the second time, the third time, the fourth time, the 10th time. And it just hits me different because it feels like we don't have that kind of understanding. And there's not a lot of room given to the understanding that things do take time. And things need time. And they need space. And so when we look at the time it takes, even for the jury instructions, they started at the beginning of trial, and then it needs to be iterated again and again and again, and they need space to do that. And this case has been a little clunky, but things take work and time. And, you know, you can't just take anybody off the street and have them do this. It's a little bit different in the fact that it feels like we're not always allowed to just have the time to make mistakes and then make it, like, iterate and make it better. And that's a very human part of the process. Like, you need room to make mistakes and iterate and then do it better. Like, nothing we do is supposed to be done right the first time. It all takes time. It just all takes time. And we don't give ourselves that time. We don't always give our kids that time. And I don't know if society as a whole gives anybody time at all. So I'm feeling very emo about my band director, Mr. A, which is, I think, where my love of just calling people by their first, last initial has come from. And you know what? My kid's high school band director, who I adore in a way that is probably annoying to him and his husband, because I love them so much. And they're just like, parent. And I'm like, no, I love band. And they're like, hyper parent. Yes. Also goes by last initial. And I love it. And I think that's where my love comes from, of all of the judges being judge insert initial here, which I never really connected until we started talking about it today. Damn. Well, thanks everybody. I feel good. I feel like I owe the chat money for whatever we've just unearthed from my soul, which I wasn't expecting to do. I was just going to have a snack. I was just going to have a snack. Just wanted to have a snack. But instead we have had a Law Nerd therapy hour, and I'm here for it too. So everybody, what's our rule of the day? We're going to just give things the space they need. And maybe yesterday when I was talking about Emily feels nervous about gardening because it takes like time and consistency and I can't forget about it. Maybe that's the direction we need to go with that. Maybe it is. But it's something that worries me about my kids very much. Watching the pressure to do things faster, decide things faster, process information faster, and to also have no mistakes. And a lot of that is not coming from their teachers. A lot of that comes from their peers. But a lot of that, I think, comes from social media. And I worry this. I was thinking about this yesterday, talking to Travis. I worry that the example that has been set for what our kids have watched is that one wrong step can be devastating when everyone is watching and when anything can go viral and when anything can just get plucked out, that there's not as much room for anonymity and there's not as much room for grace. And that's one of the things we were talking about yesterday, because both of my kids have chosen not to really engage in social media very much. And I worry that what they're taking away from those lessons is that there's no room to make a mistake ever. And there's no room to grow and learn with grace. And that worries me for them. But it doesn't just worry me for them. It worries me for everyone, truly. Because I don't think for adults it feels any better. I think for adults it feels more like we're failing just all the time. And that's hard too, that we don't have room to just process all of the information that we're intaking all the time. So what are we going to do today, chat? Disassociate. Emily, that was not the lesson. That was not the moral of the story, Emily. Yes, it is. Today we're going to disassociate and listen to Judge M talk about jury instructions. That's what we're going to do today. We're going to go to court instead. That's what we're doing. So jury instructions take time. Jury instructions take time. And we are going to just watch that unfold with some snacks. Right? We're just going to go to court. And then we'll figure out the rest of it. Oh, law nerds. I was just trying to tell a story about you can't take any kid off the street to play an instrument. And we started from the top. Now we're here. Anyway, I hope that all of you have had someone in your life that has impacted your life in a positive way, because band directors are a special breed. So are we ready to go? Oh, Warren, of course, has popped. Warren, it's good to see you, friend. I hope you're feeling better. Go team, go. Disassociate. Have I told you how many people that work on Team Baker were in band? We find each other. We find each other. Band nerds unite. All right. You guys are ready. You guys are ready for Judge M. I'm ready for Judge M. We're ready for court. We're not going to bring the jury today. We'll fly at some point, but we're going to roll the intro. We're going to get into stream. We're going to go to court. We're going to grab a snack. We're going to do all the things. You ready? I know it's Friday the 13th. The planets are doing so much. The world is doing so much, and we're just going to go to court. Because you know what? Judge M is going to be Judge M. And we're just going to see how it goes. And you know what I want to see today? I want to see if there's a full switch up, because beginning of trial, I broke this. At the beginning of trial, I was like, these attorneys have gotten along so well. Things have gone along so normally. Pretrial motions have been pretty normal. Everything is just kind of smooth sailing. And then we got into trial, and it was like the defense team was body snatched and were totally different. So I wonder if we're going to see the non-jury version of the defense today, or if we're going to see what the defense was doing in front of the jury, because it was a whole different vibe. It was just a whole different vibe between pretrial and trial. It was a wild switch up. So I wonder what version we're going to get today. Let's find out, shall we? Let's go to court. We'll see. Law nerds, it's good to see you. You guys are the best. I appreciate you for letting me chat. I was just trying to explain my analogy. I caught myself right in the feels. Right in the feels. Let's go to court. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Let's go to court. Let's see what Judge M has to say about some jury instructions. Let's see.
Versus Kouri.
Ooh, Emily, you tried to zoom, and then you went too fast. Damn it. We zoomed too close to the sun.
State of
I'm sorry. Emily, we have been on the record for less than 5 seconds, and we're already pausing for Judge M. Yeah. Crime Books Coffee in the chat said, can I get a D for disassociate? Yes, you can. Yes, you can. Look at the laptop Judge M is holding in his hot little hand. I mean, he's not a millennial. I think Judge M and I are probably the same age. He's like a zennial. He's on the cusp. But look at that. Man coming in hot with a Mac. Oh, Miss Nestor, how did you not realize that Judge M was Team Mac? Ugh, our millennial has a Mac. Yes, she said that yesterday. Yes, she did. Also, how patronizing to Ramos. Do you think Ramos is just like, I'm not your millennial, first of all. And second of all, ew. But look at that. Look at that. Look at Judge M with his Mac.
Utah versus Kouri Richins.
Just an observation.
Counsel for the state, Mr.
Just an observation.
Mr. Burmester in the courttroom.
Oh, she didn't even notice because she's just not even looking at the judge. How do you sit in court with this man and not just look at him all day?
Richins.
Kouri's got a whole different shirt going on today.
State of Utah versus Kouri Richins. Counsel for the state, Mr. Bloodworth and Mr. Burmester in the courtroom. In the courtroom is Ms. Nestor with defendant, Kouri Richins. Participating via WebEx are Ms. Lewis and Mr. Ramos. Let me just provide a little context for where we are at the moment.
We love context.
Given an honest try to updating the previous proposed set of jury instructions to reflect some events that occurred during trial, to reflect some, though not all, yet, of defendants' proposals received by the court this morning. I've also provided a working copy of a proposed verdict form. This will be an iterative process. We need to go page by page. I expect I'll need to take breaks from time to time to consider the substance of your arguments.
Good. Well, we've got Zoom room.
Let's just take it one step at a time. Mr. Bloodworth, Mr. Burmester, anything general before we begin?
No, nothing general.
Ms. Nestor.
No, Your Honor.
All right.
So I love that the judge gave his own road so far. I love that I've already improperly moved the chat. I love that the court has given his road so far, that the judge is like, all right, where are we getting started? Who's here? That Lewis and Ramos are on WebEx. Nestor's in court. The rest of the prosecution team's out. Burmester and Bloodworth are there. I don't think this indicates that Nestor's not doing closing. I think Nestor's doing closing. But I'm not surprised that Ramos and Lewis, if they're not arguing jury instructions because they're not doing closing, are in their offices via WebEx. Sure, why not?
We go by page number, working off of the draft that the court just provided to counsel. Pages 1 through...
Chat is saying that Kouri doesn't look happy today. Well, I think she's probably mad that the internet didn't like her shirt yesterday.
1 through 14.
I'm teasing. They're getting close to closing arguments. Shit's about to get real for her. So I'm joking in part. But we know that how this case is being perceived is very important to her. I imagine her mom and brother are keeping a very close eye on that. I have seen this question come up quite a lot in the chat. I did not answer it. So KF and everyone else who asked what instrument did EDB play? EDB, okay, look. We'll have to have a whole members only about teen EDB, but I started with drums, snare, then moved into quads. I'm very ADHD. Drumming made the most sense to my brain. I'm also dyslexic, and rhythm was a lot easier for me than just about anything else. However, when I got to high school, there was a very critical decision I had to make. And that decision is that the uniforms for our high school marching band were just ugly. But the uniforms for color guard were very cute and had short little spangly skirts. And I am very glad that when I picked the cute spangly uniform that I did, because color guard was amazing and the outfit won. I loved playing drums. Emily, did you love playing drums or did you love the boys that played drums? Look, both. Okay, both, to be honest. But the 90s spangly color guard uniform, we had like a mid-calf boot. It was very figure skating. It was very sparkly. And the skirts were just like, oh, they were so cute. I loved it. So I picked the uniforms. Also, color guard's fun. Throwing things in the air is the best. So color guard was very fun. It was very, very kinesthetic. We'll talk about it later.
Are the opening instructions that the court gave prior to opening statements.
Right. These are the instructions that we're going to start going through.
Any objection to including those in the closing instructions, Mr. Burmester?
Not a Hepburn.
Okay. Ms. Nestor?
Yes.
You want to reread them?
No.
Oh, good.
I'll start reading at page 15.
Oh, great.
But
I have no objections to them going back.
recent appellate decisions have chastised district court judges for not including them in the final set. So.
No problem.
Okay.
He's just like...
Pages 15.
I love that. And I imagine at some point we will see Judge M probably get pulled to a higher level of court. But I think it's funny that Judge M is like, recent appellate court decisions have chastised us for not doing this, so we're doing this. Correct. Correct. So he's including the opening instructions with the set that goes back to the jury so they can read it.
Are Muji second standard instructions without modification that were also part of the party's proposed instructions submitted prior to trial beginning. Take a moment.
Soak it all in.
No objection from the defense.
Okay.
Take a moment. Breathe it in.
Pages 24 to 25.
Oh, I love the take a moment.
The substance, I think, or is a Muji standard instruction regarding in custody informants. It would require maybe a little editing to remove some unneeded syntax. Mm-hmm. So first, I need to hear from the state about whether they have a general objection, and second, we need to make this specific, if it were given, to the time periods that Ms. Lauber was actually in custody and the evidence.
You've got the media there
regarding
today.
Those periods, because she's
victim's
not
family
in custody
there today.
during the time she's on the stand.
That's actually a good point, Your Honor.
Your Honor, the state objects to this instruction because this is for a snitch. She's not a snitch. It's a different circumstance. Now, the defense has proposed an instruction.
From the 10th Circuit?
Right.
Yes,
Okay.
Yeah,
Garcia
right.
instruction, which seems more nuanced for the circumstance.
We're going to have to
that
talk
we're
about this one in a
talking
minute.
about. So if we have to have one, then that would be the one we would
That makes
prefer,
sense.
rather than this snitch instruction.
I get that.
I looked at the case that is the genesis.
Okay, Emily, what are they talking about? All right, here's the thing. There are jury instructions regarding in custody informants. It seems to me that the distinction that the prosecution is making is that an in custody informant is not a percipient witness. Technically, or at least what most I think would consider an in custody informant is someone who is a cellmate or in the rec room. The witnesses in Donna Adelson's case technically would count. They learned about what Donna had to say because Donna was self-snitching. They overheard it. They shared it. So they learned something in custody and they were sharing the thing that they learned in custody from Donna. Carmen was in custody, but she was a percipient witness to this case. Carmen didn't learn about this case because she was in custody. She learned about this case and happened to be in custody when they went to talk to her. So I think that the difference that the prosecution is trying to delineate is between confidential in custody informants who learn something because they're in custody with the defendant versus a percipient witness who happens to be in custody. Different than like a co-defendant, different than like a co-conspirator. Does that distinction make sense? I think that's just the distinction that the prosecution's trying to make. Like, Carmen's not a snitch. Carmen's a percipient witness who also was in jail. All right. So there are instructions because there is considerations with in custody informants who are like, oh no, I was sitting at the end of the lunch table and I totally heard murderer say that they were a fucking murderer. And I heard them with my ears. There's not a lot to corroborate that. With Donna, there was the writing, but there's not as much to corroborate what an in custody informant says a defendant said, especially if they're cellies. How do I know that's what the fuck they said? You could be making this all up. With Carmen, there was corroborating evidence with the cell phone data, et cetera. So that's, I think, the distinction they're trying to make, which makes sense because the jury instructions generally say, view these witnesses with extreme caution because where's the corroboration that that's what a defendant said? And with Donna Adelson, it was written, and we saw these instructions, though, with Donna Adelson.
Of this, that...
So I stepped on the judge's statement, but that's where Mr. Burmester is arguing that Carmen's not a snitch in that context. Carmen's a percipient witness.
If we have to have one, then that would be the one we would prefer, rather than this snitch instruction.
I looked at the case that is the genesis of this. That informant was in custody at the time of trial and came from jail to trial and from trial back to jail. And so I recognize that this case isn't that.
The other thing is, Your Honor, the witness credibility instruction number 20 from page 22 allows both parties to argue whatever they need to under this circumstance. I mean, the unique thing is there is the idea that she was given immunity, or the testimony about immunity, as well as foreclosure. So that all is
should be
great
in the
for argument.
jury
I don't know that
instruction.
we need any special instruction given
Okay.
that neither
Makes sense.
person was in custody at the time they testified.
Ms. Nestor.
Your Honor, I think case law is really clear that witnesses who are either granted immunity or are bargaining in a jail setting for their own freedom when they give information, which is the
what Carmen was
circumstance with
doing.
Ms. Lauber,
Fair.
are a special category of witness. There are things that a jury can take into consideration that exceed what is contained in the normal witness credibility instruction. In this particular case, while I agree there may be some editing we need to do on the in custody informant, I think the importance of this is she was she was making a statement with the understanding that, that her freedom was contingent on it. And I think that this is an approved Muji instruction.
I mean, she was in custody,
I
but
agree
she
we
was a
should
witness.
probably limit it. When I submitted it, I was thinking all her interviews she was in custody. But I didn't think about the fact that
But then the same would be for Crozier.
she's no longer in custody. I never really looked at this instruction that way. I always looked at it as of the time that they cut the deal.
But then Crozier too.
I could be wrong about that. So I don't have an objection to adding dates that she was in custody if that is of concern to the court. I do think she made it pretty clear when she was here she wasn't. So I think the jury knows she's not currently in custody.
But also Crozier.
It doesn't matter. I'm fine putting those dates in. But I think the immunity one should be given in addition to this because the immunity agreement also covers federal immunity,
Couldn't the
state
immunity
immunity.
just handle it though?
I think we should get both. And we can just take out whatever on this in custody informant doesn't fit our facts. We can just jettison it. But we are asking for both.
Mr. Burmester.
Your Honor, a couple of things. First of all, if we're going to identify a witness by name, it should include all of them that come within the definition. So it's not just Carmen Lauber. It should be
Crozier.
Understood.
Crozier.
The periods during which Mr. Crozier was giving the interviews, he was
Yes.
in custody, correct?
Yes.
Okay.
In fact, we saw
one
an interview
yeah.
with him in custody, in
Right.
stripes.
Same with Carmen Lauber, right?
Yes.
Yeah. Okay.
And once again, this instruction,
I love that the
It's
defense is trying to chime in that not all of his interviews were in custody. Yes, ma'am. We remember that the other interviews were with y'all not in custody. We remember. But also his interviews with law enforcement happened while he was in custody. So you can't separate the two and say you want the instruction for Lauber, but not for Crozier, which is, I think, exactly what the defense wants, right?
designed for the situation where the snitch doesn't know anything about the facts of the case, wasn't a witness to anything. They
Right.
just happened to be a cellie or something like that.
Right.
And that's what this was designed for. That is not
Keep reading, Emily.
this case. Both of them were witnesses to the things they observed. There was discussion about immunity, and for that reason, we object to this snitch instruction. And if we have to have something, then maybe either add to the witness veracity instruction.
I'm not
or
surprised they're
something along the
fighting to
lines
keep
of
out the
Garcia
heavier-handed one.
mentioned before.
All right.
He gives beauty for
Let me think about this
ashes.
for a moment. Mr. Burmester,
Asked if Bloodworth isn't talking, so he's not doing closing. No, they're just arguing the instructions. Bloodworth, I imagine, is doing closing, but the other attorney is perfectly capable of arguing instructions, and then his brain can be focused on the nuance. Bloodworth can be there kind of for the umbrella of it all and the overview, but not arguing the instructions, even though he's doing closing. The person who argues the instructions doesn't have to do closing. We've seen this in most cases where someone else argues the instructions so that the person who is getting ready for closing, their brain can start thinking about closing, making notes about closing as they're listening to these instructions. So I think it's a benefit for Bloodworth to be there and not be the one who's on the bubble making the legal arguments. And that makes sense to me. We saw that in Depp Heard too. And we've seen it in other cases. So no, I think that Attorney Nestor and Bloodworth are going to be doing the closings to bookend the openings.
Putting this instruction aside for a moment, any objection to including the 10th Circuit form instruction from Garcia?
I think the 10th Circuit instruction from Garcia is fine, but I think it's duplicative if you're talking about the snitch instruction as well.
I understand.
Burmester, we got a lot going on there. Can we do a solid tie if we're doing a pattern on the shirt and the jacket?
Position to be
like, I like the jacket. It's a lot.
The state should give both instructions properly edited.
Right. It is occurring to me, if the concern is there is a federal instruction that we often use when we have what are called unindicted co-conspirators, that are people that were actually involved that then flip on whoever's didn't flip.
Slower.
Provide helpful information.
Yes, sir. Yeah. I don't like that word snitch, but
I mean, right.
That one may be closer to the facts of this case. I just than this one is. And I can pull that up really quickly. It's a 10th Circuit pattern instruction for unindicted co-conspirators.
I'll take a look at it during a break.
I'll submit it.
Yeah. Okay. We'll come back to that.
Okay.
Okay.
Chat
I've made some notes.
Just for the replay crew, there was a stark division in the chat about the color of Bloodworth's tie. Is it purple or deep navy? Maybe it's Lincoln Park After Dark. No. What's the OPI color that's like... Is it in the navy? There is a dark, dark navy blue that's almost purple. I don't know. Could we name it Rolling in the Deep? Can we just give it its own name? It's purple adjacent.
Return to this issue at some point.
Is it Russian Navy? It might be.
Pages 26.
That OPI color.
27.
It's a very...
28.
I think it's a deep
Standard
deep blue.
Muji second. Closing instructions.
I just want to hear the court say Muji more.
No, Your Honor.
I'm sorry. Which pages, Your Honor?
26, 27, and 28.
I just want to hear the court say Muji.
I think you have the fact versus expert witness in here twice. I think you have it on page 32 as well.
That's entirely possible.
So I don't have an objection to it. I just think we need to only have it on once.
I mean, right.
Yep. I will take it out of this position. I'll omit page 26, keep page 32.
Okay. All right. And then the presumption of innocence is fine. The reasonable doubt, I understand this is a Muji. I understand there's some litigation going on as we speak in other states and in this state. It has been at least touched on that the language that that evidence that reasonable doubt is evidence which leaves you firmly convinced that the defendant is guilty of the crime charged. There is some real question if firmly convinced actually properly describes what reasonable doubt should be.
Really?
I understand this.
Does firmly convinced not seem strong enough to you, chat? I mean, I guess Massachusetts uses to a moral certainty, but does firmly convinced not seem like beyond a reasonable doubt means that you are firmly convinced? Does that not, is that like, how do you express what is beyond a reasonable doubt? It is an understanding that leaves you firmly convinced. Some of you are saying, no, it doesn't really seem strong enough. And Some of you are saying, yes, it seems strong enough to me. Interesting. So chat is also a little bit split on if is firmly convinced strong enough language based on what we've seen in other courts, because that's what the defense is arguing. The defense is saying, look, firmly convinced is being litigated. Okay. I think to a moral certainty, well, former prosecutor, ask the defense attorneys what they think. I think beyond a reasonable doubt does not have to be a certainty. It is beyond a reasonable doubt. It is not a 100 because everything is subject to some doubt. That's what beyond a reasonable doubt says. Everything is subject to some doubt. But beyond a reasonable doubt is evidence which leaves you, and a lot of states will say, firmly convinced of the, I don't remember what the rest of the language is in that sentence, but of the guilt of the defendant. So I think there's room based on the rest of the phrasing, but chat also seems very split, which is fair because it sounds like the courts are split a bit as well. Because Massachusetts language is very, very high. Other jurisdictions, not so much. But then again, South Carolina has like the cloak of righteousness. Can we get that in every court? Where's the cloak of righteousness? I'm interested to hear the rest of this argument, though.
This particular instruction has been accepted by the Supreme Court, I think in case law and obviously in Muji. So I concede that but I would like to preserve that error because I'm not sure that's going to remain this way forever.
I think that's
we
a
object
wise
to the language
objection.
Of firmly convinced as being not strong enough to describe what beyond a reasonable doubt is.
I think that's a smart objection.
I understand, and the record reflects that the defendant is objecting to the definition of beyond reasonable doubt as evidence that leaves the jury firmly convinced that the defendant is guilty of the crime charged.
Oh, that's the full language. Let's play that one more time. So that's the full language in Utah as the court just read it, better than me trying to explain it. We all rather hear Judge M say it. Me too.
Okay. I understand, and the record reflects that the defendant is objecting to the definition of beyond reasonable doubt as evidence that leaves the jury firmly convinced that the defendant is guilty of the crime charged. The court notes that defendant's objection in argument is based on State versus Wall, 566 P. 3rd, 833, paragraphs 51 through 55. On balance and based upon the current weight of Utah appellate court authority, defendant's objection is respectfully overruled.
Chat wants the judge to say firmly grasp
and then
a few more times.
What was the last one you went through, Your Honor?
Well, then we go to page 29.
Chat's just like, Your Honor, firmly grasp the guilt or firmly convinced? Your Honor, one more time.
Right.
Which is not a Muji standard instruction, but is a copy and paste from the last paragraph of burden of proof from the opening instructions.
Yes.
I see no harm in giving it again. This is what you asked for, right,
Yes.
Ms. Nestor?
Yes. Thank you for doing that.
Mr. Burmester, any objection?
No.
Okay.
I think that is a smart objection from the defense. Of course, the defense is keeping an eye on what litigation is doing across the country. And
that brings us to pages 30. Page 30.
No
Muji
objection.
standard instruction.
No objection.
Mr. Burmester?
No objection.
Okay. Page 31 is the court's effort at a 404B instruction. It uses the structure of the Muji second 404B instruction, inserts the case-specific language request.
Your Honor, you have said firmly, you have said inserts, you have said pull out. Someone is gonna clip today's court proceedings into a fanfic. And not gonna be me. But all the words are happening today, Your Honor. All the words.
By defendant.
All the words.
Mr. Burmester.
Your Honor, if the court is inclined to give this instruction, we would ask that it include all of the 404B non-character purposes, not just motive. But
Do you have any other non-character purposes for that evidence?
yes, Your Honor.
Absence
all
of
but
mistake.
One or two of them, I think, can apply.
Well, but as I understood, the only reason.
Gotta whip out my book.
And when I instructed the jury in real time, the reason I gave them was motive. Was you weren't. Was it also go to
Can it go
preparation?
to identity, preparation, intent?
I'm gonna read you all the other options under 404B. 404B, character evidence may be considered for purposes such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. And that's what he's trying to rattle off without having it in front of him, which can be hard at times to remember all of them. But not just motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident.
Can, but we tried the case. Is that why you admitted it?
Your Honor, I should probably speak to that
Yeah.
one. The answer is yes, and it's been throughout
Bloodworth, let me handle this.
our briefing since, the entire motions in limine practice, we, argued for the
I left my lip
admission
gloss in my purse.
based on motive, intent, plan, and preparation and identity. Those words are always lumped together in our briefing.
I know, and talismanically, but not necessarily with factual basis. And so help me out. If I'm going to tell them that they can consider them for those specifics, there's got to be a basis. Or we can say other purposes such as motive.
Opportunity, absence of mistake, preparation, plan.
The reason I'm coming back to this is I want to be as close to the instruction I gave them as real time as possible, which we litigated in real time. And I didn't say the talismanic words in real time. I said motive.
Yes, Your Honor, but I think the court said motive based on what the defense was requesting in the instruction. The state wasn't limiting the instruction at all.
May we say such as rather than all of those combined?
I'm sorry, could you just say it in a sentence?
Yeah, such as determining motive, preparation, plan, or identity.
Yes, that sounds fine.
Or
I like that.
determining things such as motive, plan, preparation, or identity.
The limited
Opportunity.
purpose of determining
He just went to the book
things
too.
such as the defendant's motive, plan. Okay.
Yeah.
Yes, sir.
Okay. Ms. Nesser.
Well, I
That's
think
what
the
the
court
rule
was
says.
right initially. I've never been under the impression identity was an issue in this case. I don't understand how any of these things would go to plan or preparation. I think the way it's written is correct. So,
Oh no. Kouri's financial stuff and some of the other bad acts definitely go to preparation and plan.
I would object.
Certainly the first bullet point would go to preparation or plan. Plan, not so much preparation.
I don't know.
I just
Forging a life insurance could be other bad acts. Forging a life insurance the end of January could be preparation and plan. If the plan is to kill him and get the life insurance.
would like the record to reflect we object to it, Your Honor.
Yeah,
Okay,
it reflects
hold
it.
I'll just make a note of this.
Just
We'll come back
follow what 404B says. I understand where the defense is objecting to it. I think you have to follow 404B. That's where I'm at. Chad, I will ask, a lot of you have asked, including Monuments of Speculation, if we could interview Bloodworth. I will ask. Here is my initial thoughts on that. A, I will ask B, it depends on what happens in this
Okay.
case.
32.
But we must be mindful that there is a subsequent criminal prosecution that is following this case. And so there are going to be some restrictions on what the prosecution can say, given that there is a pending case. So it might be more of a, hey, Mr. Bloodworth, tell us about you, and less of a talk to us about Kouri Richins in the case. And I think that would probably work. We'll set expectations there, but I'll ask.
33, 34, 35, 32 through 36.
Yeah, more like our chat with
Are
Alessi.
Muji second standard instructions.
No objection from the state.
Your Honor, on 33, the law enforcement officers, I think that should be plural. Many law enforcement officers testified. So I think we have it in the singular right now.
Okay. You heard the testimony of law enforcement officers.
Yes.
Got it?
And then the rest, I don't have any objection to.
Got it. Will do.
A lot of you are like, can we talk to the judge? I think the only way we could get the judge to convincingly chat with us is if Emily set up an entire day of like CLE credits and had the judge come and speak to us about, you know, the law in their jurisdiction or something. I think we would have to set up like an actual day for CLEs. Like it would have to be beyond an interview. Judges don't do interviews, but judges do talks about legal topics and concepts, so like bar associations and stuff. Shit, do we need to start our own bar association? Damn it. We might need our own.
Okay. 37 versus page 38. 37 is the motive instruction that the parties proposed pre-trial. It talks about Kouri Richins' motives, plural.
Motives.
Little fuzzy regarding the law. Here, there are two aggravating circumstances. One qualifies as a motive, the other qualifies as means. The motive would be an element to the extent it's the aggravating circumstance.
That was funny.
The means is an element to the extent it's the aggravating circumstance. In the abstract, if the jury were to
Interesting.
find unanimously regarding the means, but were not able to reach unanimous agreement regarding the motive, there'd still be a basis for a conviction. So the state proposed, the court proposed the version on page 38.
Interesting. He's talking about, that was a rude pause. There we go. He was talking about the motive being part of the aggravating factors. Remember, this is not a first-degree murder trial. This is an aggravated murder trial. So there is a plus to that takes it above first-degree murder into aggravated murder. One of those things is murder for pecuniary gain. So when we're looking at aggravating circumstances, the motive is also one of the aggravating circumstances. However, the judge is exploring the fact that the jury could come to a murder conviction but not agree it was for pecuniary gain. I think that's less likely given the facts of this case, because I think that if you are looking at this case going, yeah, I absolutely think Kouri Richins killed her husband, I think it would be hard to get to that conclusion without adding for the money. It's hard to get to, I think it would be hard to get to a conviction, but not agree that pecuniary gain is a part of it. But the jury could do that. They could choose to do that. And so I think that's what the court is trying to parse. Lori O'Brien said, EDB, have you always been this funny? My teachers did not find me very funny growing up. I think I have. My fifth grade teachers would disagree. I mean, that tracks all the way through. I think my law school professors definitely enjoyed our conversations, I think, a bit more, but not always the case earlier on. So I can see where the judge is
clarify?
like-
I was with you up until the very end of what you said, but I think the court's probably right. Are you saying that the only thing that requires the motive is the subsection 1 of the aggravated murder, which is committing homicide for pecuniary gain?
Well, so if we go to the elements instruction, we just
Right.
want to look at that together as an
Right.
example.
Ooh,
So
yes.
go to page, for example, page
The elements would
41.
be helpful.
Right.
You could have 8 jurors that unanimously agree on elements 1, 2, 3,
You read
and then when it
them.
gets to 4, they're going to have to unanimously agree regarding one of the 2 at least.
Correct.
Now, they could unanimously agree regarding 4B without ever agreeing regarding 4A and without ever agreeing that about a motive at all,
Right.
just regarding the act.
Can you read them?
I think that's right.
And so the way the parties had written it beforehand did not contemplate that possibility.
I think you're right.
I'm just not convinced that motive is coextensive with intent. And I think the state is required to prove it was the intent of the defendant to cause the death
Interesting.
for the purpose of.
Yeah, the difficulty here is the pecuniary gain is a why.
Is an
not
aggravator.
how, and why is motive.
Right. That's right.
Well, if you motive might be my financial situation is so distraught, I'm going to commit this murder. Or I'm just so darn greedy, I just want more money, so I commit a murder. I think motive might be involved in both, but I have to prove that was the intent to do it, was to make the money, whether you had the motive, this underlying thing or not. I don't know.
I believe intent goes to intent to cause death.
Burmester is trying to separate out motive from intent, but the thing is, and I think Nestor is probably right on this when she's like, no, the intent's not speaking to that. You don't have to, there's motive, there's aggravation, and then there's intent. And Burmester is trying to parse those out a little bit more. But I
among the things that the jury would have to
agree
find
with Nestor
unanimously.
on the intent
Right.
isn't going necessarily to that.
The pecuniary gain is clearly motive. That is a motive
It's also an
that they've
aggravator.
alleged. And I agree that I think subsection B does not require a motive because it doesn't matter why she's administering the lethal dose, just that she is administering the lethal dose. And I think we just missed that in the one we submitted. I think the court's right that motive only applies to 4A, and so it's tricky to explain this to a jury without a side-by-side analysis of the elements instruction.
Now, another option, right, is just to not give a motive instruction.
That would probably be the best. Except that
The state's going to want motive.
Because then we don't have to get confused about whether
The wild change up between Nestor arguing when the jury is sitting in the hallway and Nestor arguing when the jury's not there is so different. It is such a wild change. And she's like, no, I kind of agree with you guys. I kind of see where we're at. A totally different person today. Ugh. What is
why
happening?
is part of 4A versus 4B. We can just not instruct regarding motive.
I don't think Burmester agrees.
I mean, I do believe the motive is there in the elements instruction, whether we explain whether it's a motive or don't explain whether it's a motive, they still have to prove this. So I'm okay with no motive instruction.
If we take the motive instruction out, it kind of frees everybody up to talk about what they really mean.
Right.
Without having to thread the needle of
Can you
what's
put
an
it in a
element and
different,
what's not.
isn't there a
Let's do that.
separate motive instruction?
Okay.
Okay,
Any
Burmester
objection, Ms.
agrees with
Nestor?
that. Isn't there a separate motive instruction? Sounds like Burmester agrees with that. But isn't there a separate one? No? Maybe? I guess we'll find out.
To omitting a motive instruction entirely. A separate motive instruction.
Yes. Okay. Thank you. Emily, keep fucking reading.
That
makes sense.
I think it's just utterly confusing. It's going to confuse the jury. I think we should take it out.
Understood.
But then there's a
Pages
separate
38 and 37 are omitted. Okay. Page 39 includes.
I know it's hard to try to follow along when we don't have the pages in front of us. We don't. I checked the docket for them. They weren't filed. If the jury instructions get filed, then I will make them available to all of you if you want to read along tomorrow. I know I didn't make our keep reading emoji yet. I need to do that. It's on my docket.
In fairness, I'm not sure I got them all, so we may have to add some more in here as we go.
Your Honor, I think we've removed the domestic violence recitation, so the cohabitant and direct definition isn't needed anymore.
Yeah, it was unclear to me. It is a
sentence
domestic that I
violence
read regarding
case.
counts 1 and 2 as part of the reading of the information, but we can take it out and just proceed as if it doesn't matter. What's the state's position?
I don't know if it aggravates anything.
Go ahead.
Your Honor, I know we didn't pull it as, I guess we pulled it by agreement as an element of the offense, not as a sentencing enhancement.
Right.
So I think the status quo is the parties agree that if the defendant is convicted of counts 1 and 2, that there is the DV sentencing enhancement automatically.
Right. That's right.
Oh, then you don't need the jury to find it.
sentencing, not to
But
conviction.
don't
Oh,
we
yeah, then
need
the jury doesn't need to find
jury
it.
to specially find it beyond a reasonable doubt in order for me to rely upon it at sentencing?
Your Honor, I think that was
The
part
parties
of the
agreed.
stipulation, is that it is just a stipulation of finding.
Okay.
The court's going to be able to find that, Your Honor. They were cohabitants.
Well, I
They
just
were
need
married.
a waiver of Ms. Richins' right to jury determination.
That makes
on
sense.
And I can make the finding afterwards if that's how you want to proceed, or you can just stipulate to the fact now. I genuinely don't remember what we did with this prior to opening statement.
We
Okay, that
do
makes
not
sense.
want the issue of domestic violence in any way to be considered by this jury because it has not been addressed. It's too confusing.
Okay.
And in return for that, we
Okay, what they are talking about. Let me pop in. What are they arguing about? They are talking about whether or not the jury needs to find that there is a domestic, under the law, defined domestic relationship here that makes this case eligible for a domestic violence sentencing enhancement. So they are discussing whether or not the jury needs to make that specific finding and whether they need to find that Kouri Richins and Eric Richins were cohabitants, et cetera. That goes to a sentencing enhancement versus a factor of guilt. So they are trying to figure out if they want the jury to decide that. And Nestor is saying, no. We don't want the jury to have to make the decision that we don't want them to even think about defining domestic relationship, cohabitation, etc. And we are willing to stipulate that if Kouri Richins is convicted of murder and attempted murder, then we stipulate and agree that she and Eric Richins were in a domestic, as defined by the law, relationship. They were married, they were cohabitating, they were in a domestic partner relationship. So the defense is saying we are willing to stipulate so the jury doesn't have to make that finding. Often when there are sentencing enhancements, the jury has to specifically find that the sentencing enhancement is true. You'll see this with like gun charges and stuff, that you have to find, you can find that somebody shot somebody, but then you also ask the jury, do you find that person A used weapon 1? Did this person personally use a weapon? And the jury will be asked to make those findings that go to sentencing enhancements. Do you find that there was great bodily injury? Those sorts of things. So this is regarding a sentencing enhancement and whether the jury needs to specifically find it. Cecilia asked, where is the violence? The murdering would be the violence. So poisoning would count here. So the fact that they are in a domestic partnership, they live together, they're married, etc., is what they are trying to define here. So harm being caused to someone in a, and I don't know how Utah defines it, but being caused in that cohabitation relationship is what they are trying to consider. So would they be considered domestic partners under the law? The defense is like, we're going to waive that. We don't even want the jury to think about it. I mean, the jury knows that they were married, that they have kids together, but murder does not have to be with a weapon to be considered violent. So that would be the domestic nature of the case.
Agreed, we would not challenge that they were cohabitants if the court has to be faced with determining whether or not there should be a sentencing enhancement for that.
Okay.
I mean,
At sentencing.
May I put it in?
If Kouri is convicted of count 1, some of this isn't going to matter because count 1 aggravated is LWOP. So the sentencing enhancement for the murder of a domestic partner is not going to change the sentencing that much. Marianne asked, why does it matter if they were cohabitants? Because if they are cohabitants, then there is a domestic relationship. Then the domestic relationship is a sentencing enhancement. If you, there is a sentencing enhancement in Utah for that can be considered. So that is why.
Considered by this jury because it has not been addressed. It's too confusing.
Okay.
And in return for that, we agreed we would not challenge that they were cohabitants if the court has to be faced with determining whether or not there should be a sentencing enhancement for that.
Okay.
At sentencing.
May I put it in my language and to see if you're comfortable with it?
Yes, sir.
Ms. Richins has the right to have a jury determine whether she and Eric Richins were cohabitants beyond a reasonable doubt. Is she waiving that right and submitting that issue to the court for determination by the bench?
She is.
Okay. Ms. Richins, do you understand the rights you're giving up?
Yes.
Okay.
Oh, they're
Are you
waiving it now.
Those rights knowingly and voluntarily?
Yes.
Okay. I accept your waiver. Find it's knowing and voluntary.
That makes sense.
On that basis, I'll remove any reference to cohabitant throughout the instructions.
Okay.
Agreed, Mr.
Julia, they were married, but we're going to get into deeply nuanced areas of law. They were married. However, marriage is not required for it to be a domestic relationship. So they are stipulating that they were cohabitants. That's why the judge is taking the waiver on the record. I will roll it back again, but that's why the judge is taking the waiver on the record, that the jury does not need to find that Kouri and Eric were cohabitants. They are stipulating to that for the purpose of a sentencing enhancement if Kouri Richins is convicted of count 1 and 2. So that's where they're making that determination, because there can be violence between cohabitants even if they are not married. So Ms. Scarlett asked, why is that an enhancement? Ask the legislature in Utah. I imagine that the legislature in Utah determined that you take it out of a murder case and into a different type of case, that walking up to the street and punching someone is different than punching your domestic partner. And so they have decided that those things are different and there can be a sentencing enhancement because of the different type of relationship. It's just like I don't know. There are different rules if you are a nurse on how you report things than if you are somebody on a street and you see a car accident. There might be different obligations and rules governing the way you operate in a certain relationship or society based on your job, based on other factors. Not everyone is a mandatory reporter, but some people are because of their jobs. So when you look at it in that context of like some people who are mandatory reporters, some people who are not, it's different. So there are different evaluations for different types of behavior. Just like financial abuse and fraud are one thing, but elder financial abuse generally has sentencing enhancements. So it's enhancing the punishment for things that are considered more egregious. So an attempted murder with a deadly weapon has a weapon enhancement versus a attempted murder without a weapon. There's no weapon enhancement. So it just depends. Hopefully that makes sense. We don't have all of the laws in Utah. The way they do sentencing is very different in Utah than in other jurisdictions. But the legislature will enhance that. But again, chat's asking, were they not married? It doesn't matter if they're married. They were married, but that's not the consideration. The consideration is if they are cohabitating. That's how it's defined under the law. So roommates would count. Like you can't go, punch your roommate while they're asleep. There's a vulnerability there. When you are living with someone, there is a different type of vulnerability. And it would be if you live with your cousins, there is a different type of vulnerability, an expectation of safety with the people that you are living with. So it would count when you are cohabitating. So marriage is not the through line on that. It also includes generational families, kids, etc. So the trigger on that is the cohabitation, not the relationship, formal relationship status. And a lot of places do that. In a lot of places, cohabitation is the trigger. I don't think I've seen anywhere where marriage is required and where anyone's had to come to court and actually prove that they were married. Cohabitation is normally the thing that they have to prove, if that makes sense. Okay. Continuing on, hopefully that makes sense. So let me rewind that because the judge takes the waiver on this sentencing enhancement that will only trigger if she's convicted of counts 1 or 2. It does not trigger on the other counts.
To be considered by this jury because it has not been addressed. It's too confusing.
All right, let me back all of this up as they are talking about whether they are going to remove all of the considerations of the sentencing enhancement.
Is that it is just a stipulation of finding.
Let me back up as Bloodworth explains it. So hopefully that makes sense.
The parties agree that if the defendant is convicted of counts 1 and 2, that there is the DV sentencing enhancement automatically.
Right. That's right. It goes to sentencing, not to conviction.
But don't we need the jury to specially find it beyond a reasonable doubt in order for me to rely upon it at sentencing?
Yeah, I think that was part of this. The stipulation is that it is just a stipulation of finding.
a fact, right?
Court's
It's a
gonna be able
fact.
to find that, Your Honor. They were cohabitants.
Well,
It's a
I just
fact
need a waiver
that they're
of
cohabitating,
Ms.
right.
Richins' right to jury determination on that, and then I
That makes
can
sense.
make the finding afterwards if that's how you want to proceed, or you can just stipulate to the fact now. I genuinely don't remember what we did with this prior to opening statement.
We do not want the issue of domestic violence in any way to be considered by this jury because it has not been
That makes
addressed.
sense.
It's too confusing.
Okay.
And in return for that, we agreed we would not
Argue.
challenge that they
Right.
were cohabitants if the court has to be faced with determining whether or not there should be a sentencing enhancement for that.
Okay.
At sentencing.
May I put it in my language and to see if you're comfortable with it?
Yes, sir.
Ms. Richins
makes
has the
sense.
right to have a jury determine whether she and Eric Richins were cohabitants beyond a reasonable doubt. Is she waiving that right and submitting that issue to the court
She
for
is.
determination by the bench?
She is.
Okay. Ms. Richins, do you understand the rights you're giving up?
Yes.
Okay. Are you waiving those rights knowingly and voluntarily?
Yes.
Okay. I accept your waiver. Find it's knowing and voluntary.
Right, that makes sense.
On that basis, I'll remove any reference to cohabitant throughout the instructions.
So
Agreed, Mr.
they
Weber?
waived it
Yes.
because
Or Mr.
it's
Weber,
just,
sorry, Ms.
it
Nestor,
makes
any
sense.
objection?
No, Your Honor.
Okay.
Okay, is this, Fred, Mr. Burmester, is this definition?
Is Mr. Burmister's name Fred? Oh, Mr. Burmister, every time I was yelling Fred at stream, I was talking about my very, very sassy orange cat. I was not yelling at you, Mr. Burmister. Now I have to double check the filings.
Of attempt,
Yeah,
the same as yours,
that was added by the court before I ever
before you
got a
did this?
chance to ask him to include it. It appears to be the same thing, so.
Okay, just one moment, Your Honor. Can I just compare something just very quickly on the
Yeah.
attempt?
We'll we'll need to take a break, so put a pin in it if you want.
Just take me 1 second.
Put a pin in it. Put a pin in it if you want. You don't have to. I'm going to some of my filings on this because I'm very curious if Mr. Burmister's
Okay. All right,
First name
so
is Fred,
we can just
'cause
toss
it would be
this, right,
delightful if
Mr.
it was.
Burmester? We can
Yes,
throw this
yes,
out.
absolutely.
Okay,
That is,
all right. No objection to the rest of the definitions instruction, Your Honor,
Okay.
or to number 40, which comes after it.
Thank you. Mr. Bremer, is there any objection to page 40?
no.
All right. That brings us to pages 41 to 42. Elements of criminal homicide, aggravated murder, count 1.
Ooh, I want to hear all of the elements. So Mr. Burmister's name on his filings is Byron F. Burmister. So do we go by Fred? Does the F stand for Fred? I'm going to go with possibly. That Fred is the middle name, but he goes by his middle name. Okay. Sure. But Byron Burmister has such a alliteration to it. You've got Brad Bloodworth and Byron Burmister for the people. There's so much alliteration. I like it.
It is the italicized language that represents a addition or proposal by one party or the court.
So
Okay.
the italicized language included under number 4, the concern that I have in this case, and
When they are talking about italicized, I will try to pull up some of the emojis, but if you have never seen jury instructions before, they are a little like a choose your own adventure where you have to pick which grouping of language applies to your case. So when they're talking about the italicized, that is language they are going to have to pick what goes in and what comes out of any given instruction.
Aggravated murder, count 1. It is the italicized language that represents a addition or proposal by one party or the court.
So the italicized language included under number 4, the concern that I have in this case, and there may be a better way to deal with it than this, but I wanted to just bring it all out for discussion, and I'm not really
Mention it all.
married to how we address it. But I think you know where I'm going with this. So there is testimony that has come in, or evidence, either testimony or documentary, that could let a jury find that Ms. Richins purchased oxycodone thinking it was oxycodone, and it was actually a fake oxycodone that neither she nor Mr. Richins were aware had fentanyl in it. My concern is if the jury thinks that under that circumstance it would be aggravated murder, which it would not. It would be a different offense, which is not charged here. It could be a lesser included offense. So I don't know how to carve out. It's my reading of this statute and the information that in order to convict Kouri Richins of aggravated murder, which is this count, they have to believe that she knowingly and intentionally caused his death. If a jury is confused about whether knowingly and intentionally causing someone's death means buying something you think is oxy, giving it to someone and it's actually fentanyl and they die, that's a problem.
Well, pause for a minute. Let me ask you some legal questions.
Interesting.
Right.
So I acknowledge that you tell me.
Okay.
I'm learning about this in researching these instructions and seeing your proposed language.
Right.
Assisted suicide manslaughter is a crime with specific elements in the state of Utah, right?
Right.
Under 76-5205.
Right.
But doesn't that require someone's like consent though? What? That can't be their proposed language. No.
When they die, that's a problem.
Well, pause for a minute. Let me ask you some legal questions.
Right.
So I acknowledge that you tell me.
Okay.
I'm learning about this in researching these instructions and seeing your proposed language.
Right.
Assisted suicide manslaughter is a crime with specific elements in the state of Utah, right?
Right.
Under 76-5205.
Right.
If, for example, a defendant in a murder case wanted to request a lesser included offense based on this factual theory, they would have a basis to do so because that lesser included exists.
Correct.
That's not the same as saying, though, that the state has to disprove that alternative beyond a reasonable doubt. It's not an affirmative defense.
That makes sense.
I agree with that.
So I don't think I have to include that language in the
Unless
elements.
you're asking for the lesser
The real
included.
question is whether you're asking for a lesser included or...
Right.
I mean, you could certainly argue to...
The judge is just making noises at this point, right? The judge is like...
the jury some factual inference that...
Yeah.
Listen, there's an inference to be drawn here that she got this stuff for him because he wanted it.
Yeah.
She says that in the walk the dog letter.
That line of reasoning or doubt.
So...
But I don't think the state has to affirmatively prove without a reasonable doubt
Unless they're
that this
asking for a
isn't,
lesser included.
assisted suicide manslaughter.
So I think that the state has to prove it was a surreptitious administration. And I don't know how, I don't think it's enough if she administered it by handing it to him and he said thanks and ate it and died. So I don't know how
What's with the ate it?
we address that with the jury.
Does that follow from the elements in the statute?
It says by the administration of any substance, and it doesn't say, I just don't think that's aggravated murder. If she administers it by handing it to him and he's...
Poisoning's not the only Poisoning's not the only aggravation here. The aggravation factors include pecuniary gain, etc. Okay? Chat, they are not just hang tight, everybody. I know. We'll break this down after we get to the end. This is literally watching the sausage get made in the jury instruction process. Here are the different theories. Here are the things that could happen. This is done outside the presence of the jury for a reason, but there is nothing weird about the defense exploring every single potential path to get the best result for their client. So she's not arguing that this is an assisted suicide. Like, the facts don't bear that out, but she's trying to get the language in the jury instruction. And the judge is like, no, the language isn't going in there. Like, she thought she was giving him oxy, but it was laced with fentanyl and he accidentally died, and everybody thought that they were giving him a pain pill. She's trying to navigate where the jury instructions fall to allow the jury an option, or if they want a lesser included, but a lesser included might not fly here. But do you want to give the jury an out? So this is just exploring literally every avenue of what could possibly happen.
He says thanks and eats it. That's not.
So this is not the arguments she's going to make in closing. This is a very open conversation about the jury instructions.
So I think that the state has to prove it was a surreptitious administration. And I don't know how, I don't think it's enough if she administered it by handing it to him and he said thanks and ate it and died. So I don't know how we address that with the jury.
Does that follow from the elements in the statute?
It says by the administration of any substance, and it doesn't say.
Which instruction does it say that in?
I just don't think that's aggravated murder. If she administers it by handing it to him and he says thanks and eats it, that's not aggravated murder.
Well, here, I'm going to create a very morbid and dark hypothetical.
This is all morbid and dark. So.
I told you this everything the judge says is going to get clipped into a fanfic today. Everything he says. It's just like, Your Honor, say the line. Your Honor, say the line. Your Honor, say the line. Okay.
Doesn't say. I just don't think that's aggravated murder. If she administers it by handing it to him and he says thanks and eats it, that's not aggravated murder.
Well, here, I'm going to create a very morbid and dark hypothetical.
This is all morbid and dark. So.
Imagine a healthcare provider says to a patient, would you like some morphine to help with your pain? They say yes, and then pushes the plunger way too far intentionally.
That's still a murder.
I think that's still aggravated.
That's an intent to cause the death.
Yeah.
Right.
But we've got witnesses of the state coming out talking about you can be fooled by these pills. I mean, they put that testimony
Yeah, but that's a different...
Yeah, but you've got witnesses of the state saying that after Valentine's Day, she asked for stronger shit. So there's that too. And I think part of the reason the court is navigating, explaining the hypothetical, is because normally when these conversations happen, there's no one in the courtroom but the lawyers and the defendant. I think the court is mindful that the courtroom has more eyes on it than it normally would. So the court is navigating that the victim's family is present in court, etc., because oftentimes these conversations just happen with counsel and the judge, and they're very, very frank. So they are trying to navigate what the jury instructions look like in this circumstance. And Nestor is pointing to the fact that Crozier said, if believed at the time, that the fentanyl looked exactly like Oxy 30. And so Crozier said that they looked exactly the same, that they were making fentanyl to look like Oxy 30, and he was charging the same thing for both. So that did come in with Crozier.
Element, right?
So I'm going to back that up because we're in the middle of this argument.
I think that's still aggravated.
That's an intent to cause the death.
Yeah.
Right. But we've got witnesses of the state coming out talking about you can be fooled by these pills. I mean, they put that testimony
Yeah,
on,
but that's
right?
a different element, right? You're down on 4B. I mean, I'm down on 4B. Intent to cause is up on elements 1, 2, and 3. We're talking about the how, not the intent. The intent as to the result is the top level.
Intent
that's
to cause
homicide.
death.
It's the aggravating circumstance that's 4B. Let me pause there. I'm carrying a lot of water here. Does the state see it the same way?
Yes.
Okay.
The judge is like, why am I the one fighting with the defense? State, do you have anything? Mr. Burmester is, nope, you got it, Your Honor. Keep going. We're on the same page. Yep, we agree.
Yeah.
And Your Honor, this, from reading the tea leaves on how the facts came into evidence in this argument, the state has,
That's Bloodworth.
the state is concerned that the state is concerned that the defense will not be precise in arguing the intent in closing, right?
Yes, you are. Yes, you are. You continue to read that situation correctly. For everybody who's like Emily, they're talking about 4A, 4B, C, D, E, F, G, and my brain is trying to figure out if you sunk my battleship. But that's exactly what the fuck Bloodworth is worried about. Ding, 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 ding. Ding, ding, ding. You continue to read that situation correctly. Listen to what Bloodworth says. I'm worried that the defense will misstate this. Correct.
From reading the tea leaves on how the facts came
This is
into
a
evidence
fair
in this
concern.
argument, the state is concerned that the state is concerned that the defense will not be precise in arguing the intent in closing, right? The evidence has come in, and this discussion here today has suggested that
Okay, I'm sorry that I paused. I got distracted because, I don't have it in here. The pen that Amy Richins is using looks exactly like the pen that I love for my Supernote. So I got distracted by, sorry, Mr. Bloodworth, I got distracted by Amy Richins' pen. I think it's in I have a book bag that has like what I am reading with my other pens in it that is not in my office currently, but is it in here? Emily, you really want, I don't think it's in this one, but if it's in this pen case, no, it's not. It's not in this pen case. It's got to be in my book bag. All right. Well, it looks like my clear Lamy pen. I just don't know where it is. Anyway, I got distracted. I am back.
defense is putting the intent on a specific drug to kill, and that's not where the intent lies here.
No, but would you acknowledge that if the defense were able to persuade the jury, for example, that Kouri Richins intended to give her husband a non-lethal dose of hydrocodone, that would be a permissible basis to argue that she is not guilty of aggravated murder?
That is a permissible basis to argue she's not guilty under the second element of aggravated murder.
Why not the first, second, and third? She didn't intend to cause his death. She intended to give him non-lethal painkillers.
Well, okay, second and third together.
Yeah.
You know, we've split them up here sometimes. They're in the same sentence. It's really weird that we split them up.
Right.
But the second and third together,
Right.
Sure, that is fine. But intent is not an element of 4B. Like
Agreed. Oh, I agree.
I actually agree with that too. I was just trying to figure out how to deal with this scenario and not have a jury. I guess we'll just focus on intent in the argument.
Yeah, it's intent to cause a death. Intent to cause a result, that's where the intent lies. If you intend to cause the result
Right.
by...
Intent to cause a death. If she intended to give him an entire bottle worth of hydrocodone or oxy, thinking that that could kill him too, then it doesn't matter if she thinks it's fentanyl or if she thinks it's oxy. It matters if she intends to give him enough to cause him to die. And I think one of the state's strongest arguments for that is that there's also Seroquel in Eric Richins' toxicology. So the Seroquel would seem to be the thing that you would hope to keep someone at rest where they couldn't interfere. Because in all the conversation we've seen about Valentine's Day, Eric Richins was awake enough to feel unwell and try to take preventative steps when he felt unwell, even when she said, lay down and take a nap. So when you're looking at the Seroquel being in there, if things failed on Valentine's Day because he was awake and not feeling well and could take some type of remedial action, the iteration of that would then be, okay, well, I need to make sure that the person's not awake to take remedial action. I need to make sure they can't go get aid or tell a friend or call paramedics or go to the hospital or what have you. And need to make sure he stays at rest. And the Seroquel would assist with that, wouldn't it? So the iteration from Valentine's Day to March 3rd, 4th changes the time of day, changes what it's administered with, including things that could make you incredibly sleepy. Etc. So I think that we will see that coming up in argument as to why this was different than in the sandwich. Also, the sandwich might have tasted a bit off, where maybe the ginger beer of a Moscow Mule would mask that a little bit more. So we'll see. But I understand where the defense is trying to say, well, no, if she didn't know it was fentanyl, then this is not a murder. And the prosecution saying, no. If she thinks she's giving someone a lethal dose, it's a lethal dose, even if she's mistaken about what the lethal dose may be.
And lies. If you intend to cause the result by means of administering what you think is fentanyl and it turns out to be hydrocodone and it's deadly either way, doesn't matter.
Right.
Or vice versa.
Right.
Yeah.
If you intended for the end result to be to die.
Right.
Right.
I agree with that.
I think we're all agreeing.
I agree with that.
Right.
Okay. Can we put 2 and 3 into one sentence?
We can. We typically don't in Utah because we want to make sure they separately, unanimously find beyond a reasonable doubt the culpable mental state.
I also think there needs to be a separate finding of causation. I think they should be apart.
Bloodworth's like,
So,
well,
I mean,
that
this is the way the
doesn't make
elements
sense.
instructions under Mucci typically work.
Yeah.
It's confusing.
You can send a strongly worded.
Be careful, Bloodworth. I once got sanctioned for talking about almost sanctioned. I did not get sanctioned. I got a meeting with the very cranky judge and all of my bosses because I dared to talk in closing argument about how confusing some of the jury instructions were. And I said, blame your legislature. Blame your legislature for writing these jury instructions. They are confusing. We are going to go through them together. I am sorry they are confusing. Let's walk through it together. But the legislature did this. And the judge was so pissed that I dared to question the propriety of the legislature in their infinite wisdom to make the jury instructions as confusing as fucking possible, that she literally called a meeting with all of my bosses to yell at me and threatened to sanction me if I ever did it in her courtroom again. And then the next trial, I deeply offended her by saying dude in closing argument twice. Threatened to sanction me. The following trial, when I was in her courtroom, she advised me that if I complained about the legislature or said dude in closing, that she would sanction me. So I said, you guys, same result. She called all of my bosses and said, get her out of my courtroom immediately. Yep. We did not see eye to eye. We did not see eye to eye very often. No, we didn't. Anyway, Emily, were you trying to find alternate ways to piss her off in closing? Challenge accepted, ma'am. Do not say dude. Fine. You guys will work. We'll keep finding new ways to be petty, ma'am. You want to go? We'll go. Go ahead. She never fined me. She was overturned on appeal quite frequently. I think this is a judge that if she could have tasered me in court, she would have reached over the bench and tased me. She hated my ass. Which also was amusing to me. Just fucking hated me. Oh no, I won all of those trials. Yep. She tried to undermine one of them and then got overturned on it.
Turns out to be hydrocodone.
I'm gonna let the judge
and it's
continue.
Deadly either way, doesn't matter. Or vice versa.
He's right.
Right.
Yeah.
If you intended for the end result to be to die.
Right.
I agree with that.
I think we're all agreeing.
I agree with that.
Okay.
Some in chat know about this judge. Retired off the bench. I still keep an eye for her sometimes, though.
Vice versa.
Right.
Yeah.
If you intended for the end result to be to die.
Right.
I agree with that.
I think we're all agreeing.
I agree with that.
Okay. Can we put 2 and 3 into one sentence?
We can. We typically don't, Utah, because we want to make sure they separately, unanimously find beyond a reasonable doubt the culpable mental state.
I also think there needs to be a separate finding of causation. I think they should be apart.
So, this is the way the elements instructions under Mucci typically work.
Yeah.
It's confusing.
Yeah, don't complain.
You're
right.
You can,
You're right,
send
Mr.
a strongly
Bloodworth.
worded letter to the Mucci committee, but I'm going to stick with this for now.
Look at how nice
But
he
we're going to
is.
strike.
He's like, right, you can send a strongly worded letter to the Muji committee. He would never sanction you for sending a strongly worded letter to the Muji committee. It's super fair. It's super fair to say, you guys, these are confusing. They're written awkwardly. This isn't how we normally talk. Right.
You can send a strongly worded letter to the Mucci committee, but I'm going to stick with this for now.
Yeah.
But we're going to strike.
Hello,
Let's just go
Bloodworth.
down
They're
the page here. Mr. Burns, did I
confusing.
cut you off there?
No, Your Honor.
Okay.
Objection,
We're going to strike the
confusing.
language without the knowledge or consent of Eric Richins, because the court rules as a matter of law that language does not represent an element of the crime or an affirmative defense that the state has to disprove beyond a reasonable doubt. Okay, then we get to the extra italicized language, of which I've provided two
extra language.
two versions. One more elegant than the other, and the more elegant one isn't mine. But rather than
He's
have
such
a
a humble
separate
judge.
instruction for jury unanimity, one offense in 2 ways, I thought we'd just include the operative language here. And all we need to do is expressly instruct the jury that there are multiple ways to find that this was committed beyond a reasonable doubt, but you've got to agree about which one of the 2 aggravating circumstances you believe the state has proven.
That's 100% the law. That is correct.
Yes.
For all of you that are just popping into jury instructions, MUJI is the Model Utah Jury
Right, because
Instructions.
I was going to say, I thought we did.
MUJI. And then my brain always goes to Model Uniform Jury Instructions, but it's the Model Utah Jury Instructions. Different jurisdictions call them different things. They're all called by acronyms.
This, but you're right. We put it in a separate instruction. This is much better to put it in the element instruction, I think. I like it better.
With all, I mean, let's be clear. This was Melanie's idea.
Yay, Melanie.
Melanie must be the research
So
attorney.
we're talking about the top.
I would imagine Melanie is his research attorney.
So you've got
Along with A and B,
you got
right?
two options here, right? You have the more wordy option before the or the more elegant version after the or.
I think the top one's clearer. Even though it's longer, it's clearer.
Okay, defense likes
Oh,
door
you're
number
right.
one.
I'm sorry. We'll put reason instead
What
of
is the
motive in there.
prosecution
Good catch.
like?
So,
Brittany is his court
Ms.
clerk.
Nestor, if we were to see,
Brittany is the court clerk. And I imagine that Melanie is probably his research attorney if she's working on the judicial instructions. So a court clerk and the research attorney would have very different jobs in court. So that would be my guess.
in the top version, instead of saying for the motive of pecuniary gain, may we say for the reason?
Yes.
Okay.
And I think you also have motive
In the very beginning.
in the first sentence.
Yep. The reason or means. You know, as we do this, though, I'm kind of leaning towards the second version.
Your Honor, the state does too. I also think we need to account in the second version for the possibility of finding both. I mean, you say at least one,
Right.
but there, I think we, in the next line, and you must unanimously agree which circumstance, I think we parenthetically plural it.
You want to say which or both?
Yeah, something like
Okay.
that. The
Which
state is
circumstance or
approving.
circumstances? That makes sense.
Yeah, we
They're
can do
talking
that.
about
Do you want to say
they're talking about the aggravating factors because the jury needs to find unanimously an aggravating, which aggravating factor or factors here.
which circumstance or circumstances the state has proven?
Yes.
Yeah.
Or just put a S in a parentheses, like, so it could be either.
What's that? Yeah. We'll just say which circumstance or circumstances. We're going to go with option 2, Ms. Nestor, notwithstanding.
Okay.
She liked number
the
one.
time
They're going
I
with number
wasted
2.
on option 1. Okay, pause there for a minute. With
Pause. I love the
I'm just going to
pause.
read it out loud. You tell me if it hits the ear correctly. To find the defendant guilty of aggravated.
Yes, Your Honor. Keep reading to the law nerds. Yes, it will always hit the ear correctly, Your Honor. We'll just wait to see if it does, in fact, hit the ear correctly. What a delightful turn of phrase. Continue reading. You continue to read that accurately.
The time I wasted on option 1.
Did he just say I regret the time I wasted on option number 1?
What's that? Yeah. We'll just say which circumstance or circumstances. We're going to go with option 2, Ms. Nestor, notwithstanding
Okay.
the time I wasted on option 1. Okay, pause there for a minute. With, I'm just going to read it out
Delightful.
loud. You tell me if it hits the ear correctly.
Okay.
To find the defendant guilty of aggravated murder, you must unanimously agree the prosecution has proven at least one circumstance listed in element 4 beyond a reasonable doubt, and you must unanimously agree which circumstance or circumstances the state has proven. If you find the defendant guilty of aggravated murder, you must determine, we'll get rid of that sentence. Got it, thank you.
That's why you read it out loud.
And we'll just keep you, we'll mark your decisions on the verdict form. Okay.
That makes sense.
Ms. Nestor, anything else there?
Leonards, I know you're not evaluating it for whether the jury instruction is proper or not, but did it hit the ear correctly? You let me know.
Just a moment. I'm getting a text. I just want to make sure I'm listening to my co-counsel here.
Well, isn't she on, like, WebEx? Can't she just chime in?
That's about okay. No, that's fine, Your Honor.
Okay. I will make
Chat
similar
agrees.
changes to the elements of count 2. So we'll get rid of the italicized language in element 4. We'll strike the inelegant option 1, and we'll get rid of the reference to cohabitant. And then we'll add the or circumstances.
Okay.
This has got to be difficult to follow for the audience and the family. I don't know if they had a chance to talk to the prosecution before this and understand what is going on with jury instructions, but this is something that oftentimes families are just not there for. I can understand wanting to be there for every step of trial, but a lot of times these things are done at the end of a court day or what have you, and families are not there. But Lewis and Ramos are on WebEx.
Okay.
So that's why they are not in
With
court.
respect to the definitions of mental state,
I imagine they're working on other things.
murder is one of the, or homicide is one of the rare crimes where it is a result-based crime, not a intent or action-based crime.
Yes, someone actually
right?
does have to die.
Notwithstanding your best efforts, if you don't kill someone, you did not commit homicide.
Hence the attempted murder.
The mental state definitions have to be specific to counts 1 and 2, and they are different, I think, than counts 3, 4, and 5. Is that the state's view of it?
It's certainly with regards to 1 and 2. One would think this is a super easy thing to figure out if
It is
something
not.
is specific or general intent crime.
Yeah.
And I've struggled with it for 30 years. Maybe that indicates I'm stupid. But
Mr.
I have
Burmester,
no
we would
objection
never.
to proceeding with the way the court is laid out.
Okay.
Right, because
The mental state's definition on page 46.
Right. I think initially the ones we submitted, Mr. Burmester had actually put it on the bottom of the counts, and it was, I like this better, separate.
Okay.
I don't know. I always question whether jurors ever understand this, but I think this is the best shot we
It's
have
your
at
job
getting
to
it to
explain
them.
it to them.
Yeah, in fairness, I should probably move mental state to find counts 3, 4, and 5 to after.
After you
The
give the
elements
elements instructions. I think
So-
that would be better.
But while we're there, Mr. Burmester, I understand you to say no objection to pages 45 or 46. Is that correct?
Correct.
Okay. Ms. Nestor.
So
It
you're going
is
to
hard
move
to
what's on page
explain.
46 behind the elements instructions for 3, 4, and 5.
Correct.
That's better, I think.
Okay. Any other objection?
Just 1 second, Your Honor. I think this is
So-
the same language we had.
A lot of you have asked about what Kouri is writing. At this point, Kouri also has a copy of the jury instructions that they're discussing. And so it looks to me like she is kind of lining out and making the corrections as they're discussing it and following along. Do I think that somebody without legal training understands every nuance of everything they're arguing? Probably not. But is it easier to follow along when you have it in front of you and can kind of line things out as they're talking about it? Yeah, it's much easier to follow along. So it looks to me like she has a copy of the instructions from her attorney to work on that.
Yeah,
And to stay
no
kind
other
of
objections
connected
to
to what they're doing.
Okay.
It also seems she interacted a lot more with Nestor than Lewis
All right.
throughout the trial to me.
I have lots of questions regarding elements of.
You have
3, 4,
questions, Your Honor?
Yeah.
The Lawners have questions.
So,
What is happening today? I think Nestor got like a full 8 hours of sleep and some caffeine and is just in a whole different mood today. What is happening?
all right. I have lots of questions regarding elements of 3, 4, and 5.
Yeah, so do I.
So I got to pull the information. We got to look at the statute. Bear with me for one moment.
It's a whole oddly different vibe.
Melanie, I'm not ignoring you.
Everyone in the chat named Melanie just swooned, Your Honor. You can't do this to me. We try our best to stay on topic. And then.
All right, so let's focus on count 3 for a moment. It's insurance fraud, allegedly committed somewhere between January 29 and August 31. It is charged under Utah Code 76.
Here's your charging.
6, 521.
They're talking about the
2D, right?
Oh, I'm sorry. Chat formerly identified as Elizabeth. Chat now identifies as Melanie. Chat's like, no, I am Melanie. Get in the car, Elizabeth. Okay, continuing on.
All right, so let's start with coupled my mental state. Because the statute does not specify a mental state, it's intentionally, knowingly, or recklessly, correct?
Well, it says it specifically in Part D.
Oh, with the intent to deceive or defraud.
It's a specific intent.
Oh, there we go.
Yeah.
So this is where it gets confusing because 2 says with intent to deceive or defraud, and then 2D says intentionally, knowingly, or recklessly devises a scheme. So different intents for different parts of the elements, right?
Yeah, okay.
Yes.
Okay.
Yes.
Fraud was not your favorite then. Your Honor, fraud's not your favorite? Yeah. Getting into fraud statutes is a whole different can of worms. Fraud
Devises a scheme
my
or
favorite.
artifice to obtain ... anything of value by means of false or fraudulent pretenses, representations. So, 2 questions here. I don't see from
say
an insurer
again?
anywhere in the statute.
Agreed.
May we strike that language?
Yes, from the state.
I mean, I don't want to add language in, so
Okay.
that's
Adding language
We'll take
in
that out.
is a problem.
And then, Ms. Nestor, in your submission this morning, you make reference to 2D's
right. Let me pull that.
phrase, fees for professional services.
Right. So I read this statute differently than the state does. I think they're trying to shoehorn a crime that is a different crime under the statute. I think if you read the plain language of the statute, taking out fees changes the whole nature of what this crime is. I think this is actually not the proper crime that they meant to charge, but now that they've charged it, I think they have to do it as written.
Well, tell me why subsection
Tell me
521
why.
2D doesn't read as follows based upon its plain language.
Hold on, Your Honor, can you give me 1 second? I had to pull the statute up on my screen.
No problem.
Just let me catch up just a minute.
I want to hear what she's arguing with regard to the statute. We're talking about the 2 insurance fraud counts
Excuse me.
and what the statute that it was charged under says, because the jury
All right,
instructions,
just a minute, Your Honor.
the jury instructions need to reflect the elements of the statute. And not every single crime has a jury instruction written for it. So sometimes you have to fashion one.
Okay, I'm with you. Please continue.
All right, so 521 2, an actor commits a fraudulent insurance act if the actor with intent to deceive or defraud does one of a number of things, but as relevant to this case, D, intentionally, knowingly, or recklessly devises or scheme or artifice to obtain
something of value, right?
two categories of things in the alternative: fees for professional services or anything of value.
Why don't you just leave it at anything
then-
of value? Because fees for professional services doesn't make sense in this context. Why don't you just scratch that and leave it as something of value?
For professional services or anything of value.
Just leave it with anything
And
of value.
then by certain means. Why doesn't it apply equally to two alternative categories of things?
I read that differently.
Okay.
Those are two separate
And
fucking
this
things.
is the fun part.
Those are ors. Those aren't ands. There's the statute that I have not read does not mean professional services and a thing of value.
Two categories of things in the alternative: fees for professional services or anything of value. And then
Or.
by certain means. Why doesn't it apply equally to two alternative categories of things?
I read that differently.
Okay.
It says or.
And this is the fun part about, plain language, right? So I read it to say that this is the crime for when someone is pretending to be to get fees for selling insurance fraudulently. That's what I think this section of the statute is. And I think the fees part applies to, it should be read to obtain fees for professional services or.
I'm going to have to pull this statute up. I see what she's saying. She's saying that this particular statute section is for someone who is selling fraudulent insurance, not for someone who is buying insurance fraudulently. That's how she's interpreting it. Well, they're arguing, I'm going to pull up the statute because again, this is part of law, is being able to take something and be like, I read it this way. Do you read it that? This is the nuts and bolts of lawyering. So if the statute is meant to be implied or meant to be applied to a person selling fake insurance so that they can get the fees for selling fake insurance, that's still insurance fraud, but not the type of insurance fraud of signing somebody's name, getting insurance on them, and then getting the insurance. Interesting. All right, I'm going to pull up the section and let the judge argue with them.
And this
But I
is the
see
fun
that.
part about, plain language, right? So I read it to say that this is the crime for when someone is pretending to be to get fees for selling insurance fraudulently. That's what I think this section of the statute is. And I think the fees part applies to,
It's an
it should be
interesting
read
argument.
to obtain fees for professional services or anything of value. In other words, I'm trying to get someone to pay me as an insurance broker by making false
Keep reading, Emily.
representations about what I'm selling you. I'm selling you
Bullshit.
something that's junk. It's not what you think I'm selling you. So I'm either trying to get a fee or have you pay me for the actual product that I'm selling you, but by means of lying to you about what it is I'm doing for you. That is what I think this is. And that is not what anything to do with Ms. Richins. I think they liked the second half of that and pretended like the first half didn't exist. And that's how I read this crime, because that is a crime. There are people that go, I've represented them. They go around
Great.
and they sell junk. They sell a policy that doesn't cover anything. And they get either a fee from you as a broker, or they get a commission, which from selling you, they get a commission of the junk product. and it's fraud. And that's what I think they're talking about in this crime.
So the state has charged count 3 and count 4 insurance fraud. Count 3 is charged under 521 2D. Count 4 is charged under 521 2B1. So there are two different things charged here. So she is nuancing the argument about what the fraud is under the code section.
And I don't think it applies here. And I want the word fees in there because I think
Well, I get that you want that.
they picked the crime. They got to prove it as it's written. And they just deleted that word.
I mean, if it says or.
Well, they're not proceeding under that theory,
Right.
but it's in the alternative. I have to acknowledge the comma and then.
If it's in the alternative, that means they both don't have to apply. Plain reading of the word or.
Just deleted that word.
Well, they're not proceeding under that theory, but it's in the alternative. I have to acknowledge the comma and then the word or. And I can't consider the word insurance in the title of the section. That's non-substantive. In fairness, I see that the word insurance appears in section 2, so I understand.
Comma or.
I'm looking at the definitions, though, for the part and the definitions in 101.5, and they don't define insurance. And the legislature's got to call it something. They chose to call it this. This seems analogous to the statute for communications fraud, which really is fraud. Like the communications in the communications fraud isn't doing much. Besides requiring that somebody communicate something by speech, writing, whatever. I too wrinkle my brow at the inclusion of the word insurance, but it seems just to be a label that the legislature has used. The substance of the statute on its face says what it says. Are you aware of any reported decision?
We are not making this judge wrinkle his brow. That's what we're not going to do today. We're not going to do it. We're not going to make him wrinkle his brow.
Limiting the scope of this statute.
I tried. I looked. I couldn't find this particular because I just kept reading it over and over.
Your Honor, we couldn't make fetch happen. Will you please make fetch happen? And the judge is like, pause, comma, or. You're kind of stuck with that.
And I'm like, this is what you charge brokers with. This is what you charge, scammers in the insurance industry with. That's this crime. And
I mean, there's still scamming happening.
I object to taking any words out of it exactly as it's written because I don't think.
It's in the alternative. You get to take out the alternatives. Miss Casey Miller in the chat said Emily's going to miss listening to this judge. Yes. We were supposed to have 2 more weeks of trial. I'm still sad about it.
I think they've proved this, and I actually think they charged the wrong crime.
Yeah, we know.
I don't think that applies to the next 2, but I do think it applies to this one.
You'd acknowledge that even if we put it in, it'd be an or.
She's trying to get this yeeted.
Well,
she does not acknowledge that, Your Honor. She does not acknowledge the comma.
I mean, if you...
Counsel, you continue to read that improperly.
You take out the words or anything of value, or
No,
it doesn't make
I wouldn't
sense.
take those out.
No. I'm saying for purpose of trying to understand it in context, right? So, like, the initial part of this says intentionally, knowingly, or recklessly devises a scheme or artifice to obtain fees for professional services,
or
anything of value, and there.
Or anything of value, like a life insurance payout. I need popcorn.
Their reading of that is that or anything of value goes back to a scheme or artifice to obtain. But I don't think that's right. I think it goes to either for professional services as their broker or anything of value, like you made them buy a product from you. And so I think they should have to say exactly what it says on here, and the jury's going to just have to figure it out. But
okay, but even in your world, in your view,
yes,
Even in your world,
I hear you saying it would be
Wrong.
1, Kouri Richins, 2, with intent to deceive or defraud, 3, intentionally and knowingly or recklessly devise the scheme or artifice to obtain
something of
fees
value.
for professional services.
3A, fees for professional services, comma, or 3B,
But that's-
anything of
That's not
value.
That's not how it's written, though, Your Honor.
It's
That's exactly how it's written.
I
No,
just
it's-
put the comma and the or in the
That's exactly how it's written. He's reading it verbatim. He's just reading it. Sorry, my little fraud prosecutor heart is just like, that's not what that says.
3A, fees for professional services, comma, or 3B,
But that's-
anything of
That's not
value.
That's not how it's written, though, Your Honor.
It's exactly how it's written. I
No,
just
it's-
put the comma and the or in the same place.
No, you put a B in there, an A and a B, and I think it's all connected. I don't think it's written that way.
Oh, okay. Well, then we should take
I'm
the
not
1,
flip-
2, and 3 out as
I'm
well.
not flipping off the judge.
Take the, which one?
Never mind. I understand your point.
He's being petty. He was being petty. She didn't catch it. He was like, fine, you want to take out the A and the B? Take out the 1, 2, 3. A, B, C, document. Yeah, that. He's like, fine. If we don't want to number them, we won't number any of them. All of the numbers are inserted to try to make it easier for the jury to understand that it's this part, this part, this part. This is how all the jury instructions go. Like, what are we doing? Emily, why does it matter? Because she wants to be able to get the jury into a New York state of mind. And by that, I mean a not guilty state of mind. And so she wants to take the argument that you have to find that Kouri Richins was trying to get professional fees, which we can all agree, I think, that that's not what Kouri Richins was trying to do. She was not trying to get professional fees in the life insurance transactions. So she is trying to take the most ridiculous reading of that and say, see, this is ridiculous. She's not trying to get professional fees. Ugh. And if you can't believe this, you can't believe any of this. And so she's trying to take that one and then expand the ridiculousness of, see, clearly she's not doing that. And if she's not doing that, she's not making a sandwich and she's not murdering her husband. And the prosecution's ridiculously overcharging people out here with just crimes all the time. And who can trust them anyway? So she's trying to take this, make it ridiculous, and then expand it to the other readings so that she can argue it, because it's much easier to argue to the jury, this crime doesn't even make fucking sense. However, there's an or. And so lots of crimes have alternate theories. And then when you get to the end of evidence, you just line out the other theories. And so you just keep the one that applies to the evidence. So, yes, she is 100% trying to set up a straw man argument, which is not, it's bold strategy from the defense attorney who stood up and told the jury that medication expired when they could clearly see the expiration on the photo was the wrong date. So, it's very common that crimes have alternative theories. This crime can be committed by this or this or this or this, especially in fraud crimes. Then you just line out the ones that don't apply. But why is she fighting on it? Do you see why? It gives you the best opportunity to stand and fight. It makes sense why she's fighting on it.
Okay. Mr. Burmester, go ahead, sir.
If we're going to add the theory that we're not proceeding under, then it should be A and B to make it clear, because it is an alternative.
It's silly
list
to
of
leave
two.
it in.
Yeah. I don't know how to read it any other way.
If that's wrong, it comes back though, because that's not, these go straight to elements.
Okay. So, Mr. Burmester, any objection to include?
Did you hear what she said? Well, Your Honor, if that's wrong, then it just comes back on appeal where the word's unsaid. Your Honor, just strike it.
Including the language in the alternative form as it exists in the statute.
As long as it's A, alternatively A or B.
Okay.
I object to the A or B, Your Honor. I think it should be all one sentence, like exactly like
object.
it's written.
I understand your position.
It's written with a comma.
Okay. Let me give that some thought.
No. Ridiculous.
Your Honor,
Mr. Ramos, go ahead.
just as you're giving it some thought, and I'm looking at 76.6521, just straight from the code. An actor commits a fraudulent insurance act. I had missed it on, Your Honor probably didn't miss it. I missed it on the first one, but going
Did you
back
say
to the insurance
551?
act,
They
that
were on
isn't in
521.
the instructions as it currently is, but just highlight it now as Your Honor looks at that.
Okay. Thank you, sir.
Thank you.
All right. Very good. I've got a note there. We'll keep going. Regarding count 4, I didn't see any disagreement between the parties regarding the elements for count 4.
No disagreement, Your Honor.
Mr. Burmester?
Did we talk about element 4 of count 3? Because I'm not sure where that came from.
Oh, thank you. Yeah, you're right. I went too fast. I don't understand where that came from either.
I'm sorry, what? I didn't understand what he said.
Paragraph 4 of the elements on count 3
on
page
count 3.
47.
I'm sorry, I got to go back. Just 1 minute. I thought we were on 4. Okay, element.
They didn't, ma'am, they never moved to 4. He said anything else.
Oh, took a substantial step. That came from case law. That's case law.
Have the citation?
I did on the one that I filed. Let me pull that up, Your Honor. Just a moment. It's document 1584 on the docket. And
A lot of you are asking, where did Ramos's voice come from? WebEx.
count 3.
He's not in court today.
This is a different one. Let me see. I might have written it in my notes to the state.
Who is
Just a moment,
clicking?
Your Honor.
I'm trying to see if that docket number is on the docket. I'm taking a look real quick. Oh, no, it's an objection. All right.
Oh no, I don't think that came from me. I don't think that came from me.
I think the clicking did come from you, though.
I think it did. I can go back to what you emailed, or from the parties, and was represented as, but it's not in the statute. Neither is the definition of insurer, and neither is the definition of substantial step. That's why we have highlighted
Oh,
those.
I know
All
where
right,
this
I've got to
came
grab
from.
something. I'm here.
Mr. Bloodworth and I had a
just gonna be off
discussion
camera
about
for a
the
sec.
fact that the way that it was originally written, she wouldn't have had to do anything. She could have just imagined it and never taken an actual step towards the commission of the crime. And that language got put back in after we had that conversation. I think and we were trying to fix that problem. And I think that was what Mr. Bloodworth added to fix the problem. I was the one that originally said the way it's written, she could just think about it and be guilty. She wouldn't have to do anything.
Okay,
I think
clearly
an
no
act
thought
is
crimes.
kind of implicit in 3 by means of false or fraudulent pretenses, representation, promise, or material omission. I think that's the act here.
Well, I understand the point. It seems that the actus reus under 521(2)(d) would be the device.
Did you just say reus, not actus reus? I vehemently disagree with that pronunciation of actus reus, even if the court is correct. I had to back it up.
I think that's
Disagree,
the
Your
act
Honor.
here.
Well, I understand the point. It seems that the actus reus under 521(2)(d)
Disagree.
would be the devising the scheme, which I think is Ms. Nestor's point.
Right.
Well, if you devise it,
I could think of one
and
right
never
now.
say anything,
Right.
or do anything,
They're not
have you
asking
violated the statute?
to
Right.
So
define
what
the
is
actus
the actus
reus.
reus? What's the conduct?
By means of, and then those,
Well, but that's just a modifier on the scheme
Right.
that you've devised. I think the operative verb there is devising.
I think the judge is probably right.
I do know in federal court law, it's clear you have to take a substantial step. I don't know if they just have an objection to the word substantial, but you got to do something. Something has to be done other than thinking of it in your head.
Why don't we just instruct regarding what the state's theory of the crime is?
Right.
And either they proved it or they didn't by beyond a reasonable doubt.
That would be fine with me.
I mean, forgive me, count 3 is the... I get confused between count 3
It's
and
the
4.
scheme one with the $100,000 two-stage policy.
Yeah.
We're on count 3.
filing of the application.
Yeah, the fraudulent, false or fraudulent pretense.
It's the submission of the application with the fraudulent stuff on it, right?
It's the submission of the application, but it could also be
Just signing
filing
it.
the claim as well. But yeah,
It could be both.
Okay, sure. Yeah. You could, yeah. You could,
I think-
we could instruct the
Oh.
jury that the state's theory is that Kouri Richins committed this crime by A, B, and C. I give it,
Or.
yeah, right, yeah.
Yeah, or.
We'll take a break. You can all give that some thought, maybe talk to each other. I understand your concern. But it seems that we don't need to be coy. We can just tell the jury what the state thinks and either the state proves it or they didn't.
Yep.
Okay, give that some thought.
Did somebody give the judge a bingo card for today? What do you mean we don't need to be coy? Your Honor.
But it seems that we don't need to be coy. We can just tell the jury what the state thinks and either the state proves it or they didn't.
Yep.
Okay, give that some thought. Okay. In terms of our initial review, let's keep going. Elements of count 4. Just read through that for me for a moment. Let me know if anything sticks out.
This I don't have an objection to, Your Honor. I think this tracks the statute and it also tracks the case.
Okay.
Okay. They're on count 4.
Mr. Burmester, let me know when you've reviewed it.
On 4?
Yes, sir.
No objection, sorry.
That's okay. So then let's look at elements of forgery, count 5. 76-6-501. 2B1. An actor commits forgery if with purpose to defraud anyone, or with the knowledge that the actor is facilitating a fraud to be perpetrated by anyone, the actor makes, completes, executes, authenticates, issues, transfers, publishes, or utters any writing, so that the writing or the making, completion, execution, authentication, issuance, transference, publication, or utterance purports to be the act of another person, whether the person is existent or non-existent. This is the signing of the true stage life insurance application.
Yes.
Signing of Eric Richins' name, allegedly, to the true stage life insurance application. Correct, Mr. Burmester?
Yes.
Okay.
Okay.
There it is. You got it.
So we've
That
got to
sounds
keep
correct.
with purpose to defraud anyone in there, right?
Yes.
Out of paragraph 2.
Yes.
Okay. But then
You can narrow it down
I
a
think,
bit.
if I understand what you submitted correctly, you're asking for without the authority to do so.
Right.
No.
That's right. And that's based, I decided the case law on that. State versus Gonzalez, state versus Collins, and I think the state has agreed to that.
Is that correct, Mr. Burmester?
Yes, Your Honor. There's
There's
yeah,
case
that's
law
an
on it?
element that
Very good.
Okay.
supported by those cases.
So 2 and 3 stay in, correct?
Okay.
Yes, sir.
Yes.
And then do
There's
we need
case
to,
law on it. That explains.
can we skinny down?
That explains why the defense was arguing yesterday with the IO. Like, you don't know if Eric Richins gave permission, but I think if the jury believes that Kouri Richins stole $250,000 in the HELOC and Eric Richins was pissed about it, I think the prosecution has an argument that there's no evidence that Eric would let her sign anything like this, especially after the HELOC. But that explains why defense was kind of hammering on that point. Well, we don't know if she had permission, but we also know that he pulled all of the powers of attorney when he redid his will. If you go to the effort to redo your will, make sure there are no outstanding powers of attorney and no authority to sign, are you saying, yeah, sure, go ahead and sign that? And if you're letting her sign it, are you writing your social security number wrong? Lula said, EDB showing her age with WebEx, not Zoom. No, the court uses WebEx. I would have said Zoom if the court used Zoom. It was just the court uses WebEx. It's annoying to me, but this court uses WebEx. So I was just being specific. I'm also old AF. That is factual. But no, the court uses WebEx specifically.
Yes, sir.
Yes.
And then do we need to, can we skinny down 4 in any way to match the state's theory?
You should be able to get rid of some of that language. Yeet the language that's not needed.
Or
I don't know.
it's
that
just
we
the
have
way
it.
it goes?
Yeah, his social security number was inverted.
I mean, execute and authenticate don't really match the facts of the case.
Isn't execute just sign?
She executed it.
Because I thought execute meant
Sign.
make it effective.
No.
I don't know. And authenticate usually means notarize or something like that. I still don't know what utter means.
Well, we can go back to page, any
Are we trying to be coy? We don't know what an utterance is, ma'am.
intentional act that puts a writing into circulation and implies by word or action that the writing is genuine.
I mean, it just seems like you could say make or complete a writing. Or just make a
I think it's
writing.
make or utter.
Yes.
Make
That's
or
what I
utter.
think.
Utter's a weird word. Makes me think of a cow.
Mr. Burmester.
Well, I don't think that's a moot point. I don't know if I disagree, but Miss Nestor, Miss Nestor, ma'am, the inside thoughts are not staying inside today. The inside thoughts are just happening in real time. Some of you are mad that you thought it was funny. Some of you are like, what the fuck is happening in court? Some of you are like, yes, utter is a weird word. But the The inside thoughts are just, and the judge is like, no, we're not. We're moving on. Your Honor, we're moving on. Come on. Just for the law nerds.
The facts of the case.
I had to rewind it.
Sign.
Yeah,
The
because
judge just kept
I thought
a
execute
flat
meant
affect.
make it effective. Like, I don't know. And authenticate usually means
judge is like-
notarize or something like that.
My face is not
I still don't know what utter means.
facing.
Well, we can go back to page, any intentional act that puts a writing into circulation and implies by word or action that the writing is genuine.
I mean, it just seems like you could say make or complete a writing. Or just make a
I think it's
writing.
make or utter.
Yes.
Make
That's
or
what I
utter.
think.
Utter's a weird word. Makes me think of a cow.
Mr. Burmester, make or utter or make?
We've got cows. For everyone who mentioned Twister in the chat, I liked that movie a lot more before I moved to Tennessee. And now I'm just like, is it prophetic?
Execute or utter?
Either of the
If she says that shit in closing, I'm going to lose my mind. She's just trying out her lines for closing. I'm putting up a poll. If this is the language they keep in, assuming they don't change it, if this is the language they keep in, she makes this joke in closing, yeah? She's happy with the line? I think she's happy with the line. Does Nestor try to work the... All right. I'm putting up a poll. She going to try to work that into closing? This is we are assuming that the word of the, that they don't take utter back out of this instruction. Assuming the word isn't there.
those two alternatives are fine for the state.
All right.
She tries to make that joke.
Court rules that paragraph 4 should read, did make, comma, execute, comma, or utter a writing so that the writing or
Utters
the
in.
making
Utters.
execution or utterance purports to be the act of another person, whether that person is existent or non-existent. Do you want to take out the last clause?
I mean, we're dealing with an existent person, so
At the
it
time,
seems
yeah.
kind of pointless.
Any objection, Mr. Burmester?
No, Your Honor.
Non-existent, by the way, non-existent means like a made-up identity, not that the person is deceased.
Got it. Thank you.
A lot of fraud statutes
Okay.
will treat an utterance not just as a verbal utterance, but also written.
Pages 50, 51, 52, 53 are Muji second standard instructions.
I agree with that.
I think the judge overemphasized Muji on that one just to follow up on the utter joke, but that also might be me trying to make fetch happen.
51, 52, 53 are Muji second standard instructions.
I agree with that it is 50, but
Now the Muji.
it certainly doesn't preclude one from arguing where two charges might be related factually.
No, certainly not. The state in its closing can start with count one and then pivot to saying you can
Pivot.
consider the strength of the evidence regarding count one as part of your consideration of count two.
Okay, I just wanted to make sure we're
What
not.
we can't let the jury think is that if they find a defendant guilty of aggravated murder, well, screw it. We're just going to click guilty on the rest.
I totally understand the rationale for it, but
Okay.
as I read through it, I was,
Yeah.
I don't think she's a murderer. Screw it. Let's just tick off the fraud. Someone gave this man a bingo card today. And he's just ticking the boxes. Your Honor, you can't. Yes, you can. I'll allow it. Please continue, sir.
Start with count one and then pivot to saying you can consider the strength of the evidence regarding count 1 as part of your consideration of count 2.
Okay, I just wanted to make sure we're
What
not.
we can't let the jury think is that if they find a defendant guilty of aggravated murder, well, screw it. We're just going to click guilty on the rest.
I totally understand the rationale for it, but
Okay.
as I read through it, I was
Yeah.
kind of concerned.
Okay. Page 54 is a edited version of what would normally come after as the second paragraph of page 53 to reflect that this verdict form has a lot more blanks than just 2.
Okay.
I'll take a look. You will see, please, the verdict form is separated into, I'm just going to say several sections.
To several sections.
Yeah.
I
Okay.
told
One
you guys,
section for each count charged.
jury instructions are fascinating. The judge also fighting for his judicial demeanor to not follow up on the utter as a weird word is just a delight. You could see him just recomport his face. He was just like, nope, 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 nope. We're letting it go. So, it's a different, court has a different vibe,
Any objection, Mr.
jury in, jury out.
Couldn't understand what you said.
No problem. In the jury room, you will receive a verdict form. Please read the instructions on the form carefully. The verdict form is separated into, it currently says 2. I'll edit it to say several sections.
Okay, no objection.
Ms. Nestor.
No objection.
Okay. 55 is a Muji standard instruction. Any objection, Mr. Burmester?
No, Your Honor.
Ms. Nestor.
No, Your Honor.
56 is a Muji standard instruction. It was part of the party's proposed inclusions pre-trial. I'd like to hold it in reserve so I at least have a place to start if the jury reports that they're having trouble reaching consensus.
Well, I just don't see the harm in doing, I mean, I think, I always want jurors to be instructed by the court, not just us, that they're not to surrender their honest
Judge Abby
conviction
says hello,
as to the
chat.
weight or effect of the evidence solely because of the opinion of their fellow jurors or just to return a verdict.
I agree, and that's why you should look at paragraph 3 on page 51.
Oh, okay, did you stick it in there? I didn't see it.
No, it's just part of the standard overarching.
Ma'am! Propriety. Judge Abby's like, how's it going? I'm like, Judge M just said screw it. And she's like, oh boy. I'm like, yes, but it was in context.
A verdict.
I agree, and that's why you should look at paragraph 3 on page 51.
Oh, okay, did you stick it in there? I didn't see it.
No,
Sorry.
it's just part of the standard overarching unanimity instruction.
Oh, that's fine.
Recently had a hung jury. I need a place to start.
He's like, I recently had a hung jury. I am traumatized. I do not ever want to do it again. Also, does Miss Nestor have like a fidget ring on her finger? I think she does. I think she has like a fidget ring on her finger.
Overarching unanimity instruction.
Oh, that's fine.
Recently had a hung jury. I need a place to start to apply gentle pressure to keep working. And this is something I'd like to have in reserve. Okay, so I'm not going to
Gentle
give
pressure,
this as
you
part
said?
of the pre-closing instructions.
There is a typo on it.
I'll fix it. What is it?
Third line from the bottom, do not surrender.
Thank you.
Started from the bottom.
Got it.
Now we're here.
It's kind of an important
Started from the
section.
bottom.
Yeah. Okay. All right. May we please?
Kouri, girl, don't be bobbing your head to there is a typo here. Ma'am, we have seen your text messages. We have seen your emails. You stop moving to the, oh yeah, there's a typo. Ma'am, with your child's book. Stop it.
Reserve. Okay. So I'm not going to give this as part of the pre-closing instruction.
Watch her
There's
face.
a typo on it.
I'll fix it.
Watch
What is
Kouri's
it?
response to this.
Third line from the bottom, do not surrender.
Thank you. Got it.
That's kind of an important section.
Yep. Okay.
Or maybe it
All
was
right.
maybe it was the response to it's kind of an important section.
Please, and Ms. Nestor, we're going to come back to your submission here before I take a break.
Okay.
But let's go to the verdict form next.
Well, but gentle pressure and submission are just going to get clipped right together, aren't they?
Ms. Nestor, we're going to come back to your submission here before I take a break.
Okay.
But let's go to the verdict form next.
Okay.
Fairness, this was the last thing I did before I came on the bench, and so there may be some typos or flow errors here, but let's just go through it one time as if we were jurors answering it to make sure that it flows correctly.
I'm not gonna survive the rest of jury instructions, Chad. It's late on a Friday. I'm not going to survive. What happened to the bench, Your Honor? What flow are we just? Damn it!
Your Honor, I don't, well, unless it's at the beginning.
Oh,
I don't think I
good.
got a copy of the verdict.
Miss Lewis's voice will definitely throw some cold water on it. 100%. Miss Lewis is like, Your Honor. We're all like, Miss Lewis, the disembodied voice from WebEx.
I think it was in the email that I sent after I sent a
Verdict
copy
forms are
of the
incredibly
jury
important.
I did not receive that email.
Hold on, Wendy, I'll send it to you right now. Just
Verdict forms are incredibly
No,
important.
you did. Or at least I sent it.
I didn't get it, but
let me
I
forward
think
it.
maybe just
Okay.
resend it.
Yeah, I'll send it right now.
Thank you.
Okay. I just sent it.
I should say skip to count 2.
Oh, we're going to take out 1B. And so this has to change to right there.
Magdalena, I sent you a quick message. Lewis's disembodied voice was talking about the verdict form. We know how important? I'm never going to survive. We know how important the verdict forms are and how badly it can go when they are awkward. Yockster said, EDB, does the defendant look at these documents? She's flipping through them now while they're going through this. I don't know if every defendant would want to do that, but I think it keeps them engaged in what can be a very long and boring process. Most defense attorneys I've seen will give their clients a copy of what they're going over in court because everybody's flipping through pages and lining things out, and it, I think it's helpful. So, yeah. But I think it helps, A, keep them involved in what's going on, and B, when the lawyer needs to talk, it's like
Okay.
keeping them, this is what we're talking about, and you don't have to explain to them as they're reading along with you.
If we include it.
So I would want to, too. I would want to line it out.
Okay. So let's see. Let's start with you, Ms. Nestor.
Because they're
So we'll
modifying
take out
things in
the
real time.
Plural of inquiries, and we'll say skip to count 2. There'll be no reference to 1B. We'll just omit inquiry 1B, right?
Right.
Same for count 2. Similar changes.
Right.
Any other changes?
Yes. So I have some worries
I mean, same.
about it not
I'm gonna run out of
being-
popcorn.
I know we have an instruction on it that's separate, but I sure would like it to be clear on the form of the verdict about that it has to be unanimous as to each one.
Doesn't it say unanimously regarding each one?
It does, but you could be saying you unanimously agree.
Oh, I'm sorry. Are you under 1A?
Yes, sir.
Okay.
So let's say they checked both.
So rather than say check all that apply, if I put in parens, check all regarding which you unanimously agree.
That would
That would
solve
fix it.
Okay.
Agreed. That's fair. That would fix
would
it.
be, that takes care of my concern.
Because
my worry would
when we're talking about aggravating factors, the jury has to find each aggravating factor. And so you have to find it unanimously. And so reminding them that each of these factors also have to be found unanimously, there needs to be unanimity. Not every jurisdiction is the same on unanimity of theory. I think everybody's the same on unanimity of aggravating factors, but making sure that it's clear. And I think that's really an easy way to fix it. And the judge is just like, oh, no, yeah, makes sense. Should we just clear it up? Which I really appreciate the willingness to work with the attorneys to be like, if we need to put in an extra sentence to make it clear, let's just make it clear. It doesn't harm anyone by making sure it is expressed in a few different places. And I appreciate that the judge is like, yep, how about this? Will that clear it up? Yep, great.
they would mark them both, and we would never know that they were unanimous on each.
Okay.
Or if they split it half and half. Does that make sense?
Yep.
Okay.
Any objection, Mr. Burmester?
No.
Mr. Ramos, my apologies. Go ahead.
No, I apologize, Judge. I jumped the gun a little. Just for flow's sake, right under guilty of aggravated
For
murder,
flow's sake.
In parentheses, I would suggest flipping those. So starting, if you mark not guilty, proceed directly to count 2, and then
Sure.
After that.
That's fine.
Actually, that does make more sense.
Ramos is like, can we do it this way? Yes.
Got it?
Same on,
Remains consistent with the.
and same under
Earlier
count
question.
2 as well.
Can you let Burmester
Got it.
finish, ma'am? Lord.
Okay.
Emily, you
Then,
interrupt everyone.
Before
Yes.
we take a break,
I'm the legal commentator with ADHD. I'm not in court. I took vociferous notes in court to keep from interrupting people. It's hard. But just let Burmester finish. I mean, he does have really long gaps in between his words sometimes. Like, I get it, but
is Nestor, may I go through just what you've submitted this morning to make sure I covered it all, at least initially?
Yes, sir. Let me grab it just a moment.
I'm going to answer some questions while we're waiting. Ms. Golden Rule
Okay,
says
I'm
he
ready.
seems really accommodating to the defense. He is.
All right, we handled.
The judge has been incredibly accommodating. A lot of judges are once you get into trial, not all, but a lot of judges are once you get into trial, because at the end of the day, if the defendant is convicted in appeals, the rulings against the defense are going to come back to bite you. Rulings against the government, not generally so much. So that is kind of where we're at. Ellie B said, who has a thermos in the courtroom? It's the judge's water bottle. He has a big old metal water bottle on the bench.
The quote, without the knowledge or consent of Eric Richins,
Right.
language on the record. Changing her to there. I didn't see a spot where that would be a problem in these instructions, but
I think that only applied to the ones when Mr. Burmester had the definitions under the elements. I don't think it's
okay.
a problem anymore.
all right. 3, insurance fraud. I understand your position, and I'll take a break and make a ruling on it.
Okay.
Okay.
The forgery elements instruction, I think we've reached consensus regarding anything further there.
No, sir.
I've ruled on defendant's request for a different definition of what constitutes proof beyond a reasonable doubt. Any further record there?
No, sir.
He is incredibly thorough, which I appreciate.
Number 5. Why don't you have sufficient foundation pursuant to the witness?
This face tells me she knows exactly which direction this is going to go. The second the judge started saying number 5, the defense's face went, I'm going to lose this.
Definition
That's
of
how I
what
thought.
constitutes proof beyond a reasonable doubt. Any further record there?
No, sir.
Look at this.
Number 5.
Right.
Why don't you have sufficient Foundation. Pursuant to the witness credibility instruction on page 22, to make exactly this argument. I'm not sure this is a legal instruction so much as a strategically sound part of your closing argument.
Vibes. It's vibes, Your Honor. It's vibes.
I think the Portuondo v. Agard case opens the door for instructions like this. I do think there's nothing in the witness credibility that talks about this. And I believe in Portuondo it was used against the defendant, but I think this is an interesting issue. I mean, if you have a witness who has sat through trial and heard everybody's testimony before they take the stand, that gives them an edge. And I think a jury can consider that. And I don't think there's anything in our existing witness credibility instruction that addresses something like that. And I think we have a right to bring it to their attention and say, hey, if you want to consider that, you can, but you don't have to. And that's why we want that instruction.
That relates
because
to the
O'Driscoll
IO.
was the last witness of the case. He had some very important testimony in this case, and he had the benefit of hearing 45 witnesses before himself and all the court's rulings on everything before and every.
And he still couldn't remember half of it. But okay. He still didn't remember. You're like, did you hear this person testify? And he's like, So, okay.
Out of the jury conference and everything. So I do think that's proper, and we are asking that it be given.
Mr. Burmester, I certainly understand why defendant wants the instruction. Anything further on whether they're entitled to it?
The state disagrees they're entitled to the instruction. Portuondo didn't involve an instruction. It was exactly that an argument was made by the prosecutor about the defendant being present, and the court said that's just fine. That can happen in this case, but it shouldn't be an instruction from the court. It shouldn't. There's no basis for the court to give its imprimatur on O'Driscoll's veracity.
And,
Okay.
And can I just, before you
Sure.
rule, Your Honor?
Excellent use of imprimatur. Burmester. I'm digging it.
I am fine if you want to just take some semblance of this language and insert it into the witness credibility so it doesn't seem to highlight, as it being more important than any other thing they're supposed to consider when they're considering witness credibility. It's just one of a list. I'm fine with that too. So
Okay.
if that makes you feel more comfortable, I would do that as well.
I will, with the benefit of counsel's argument, take a fresh look at Portuondo versus Agard. After the break, give you a ruling.
Thank you, Your Honor.
Okay. I understand defendant's position regarding United States versus Garcia. Anything further?
No, Your Honor.
Mr. Burmester.
I just want to reiterate that Garcia closer fits this than their point number 11.
Understood. We took out the defendant testifying instruction. That's handled.
Right.
We took out the children testifying and the age of witness instructions.
Okay.
I've given the request for
The fact that at pretrial, the children testifying instruction was put in there causes me grave concerns. I'm very glad to hear that that is not an issue. But was the defense considering having the kids testify? And what in the world could they testify to? Ooh, I have a visceral reaction to that. I'm so glad that that's not the case.
re-emphasis of the burden of proof instruction. We have a 404B instruction. I need to just make a ruling regarding whether we'll be discussing motive as the other purpose or motive, plan, preparation, identity.
Right.
The other 404B purpose is listed in the rule. I'll come back on that. And then we've already discussed the in-custody informant instruction. I'll give you a ruling on that in a few moments. Anything further on that, Ms. Nestor?
No, Your Honor.
Ms. Nestor, anything further before we take a break?
The spoliation instruction.
You made reference to it in an email.
Yes.
What?
Spoliation is a legal doctrine that has elements.
Yes.
What?
You got to make a showing.
Yes.
What? What spoliation of evidence? I'm going to let her make an argument, but the argument is that something got destroyed and they couldn't get to it. Like Kouri's text messages. But Kouri destroyed them before law enforcement got involved. So, potato, potato. But spoliation goes to evidence being destroyed. Oh, I would guess the pill bottle too. But we'll see. You got to meet the elements, though.
Instruction.
You made reference to it in an email.
Yes.
I'm curious
Spoliation
about
is
this.
a legal doctrine that has elements.
Yes.
You got to make a showing.
Yes. I understand that.
Okay.
Do you need a break, or do you want to just do it?
Let's
knock
take
it
a
out?
break while you
Okay.
get that lined up.
Okay.
But I, like some other rules, just saying the word doesn't necessarily get a party there. There has to be a showing. I have to make findings.
I understand.
So, all right, Mr. Burmester, anything before a break?
No, Your Honor.
Okay. 3:15, folks, please. Thank you.
All right. Court's going to take a break. We're not going to take a break. We're going to zoom. We're going to see what the court's rulings are, it sounds like, when they come back from the break. I'm glad we've got zoom room. Yay for us. So we are going to take some zoom room, but the judge has just a few things left to rule on. So that's what we're going to do. All right. The judge is not back on the bench yet. I haven't zoomed yet, but judge is walking off the bench. Let's zoom. It's a longer break than I thought. That's me looking at the my third monitor while I'm trying to
Mr.
get
Bloodworth.
past our break. All right. Let's go back on the record after they took their break. See what the judge's rulings are on jury instructions.
Okay. Mr. Burmester, do we need to wait for Mr. Bloodworth?
No, Your Honor.
All right.
Wait,
Let's
where'd Bloodworth go? Did Bloodworth like yeet himself now that we're done with argument?
go back to
That
your
makes sense,
submission
actually.
this morning. We'll use that as a list
makes
here.
sense.
First, with respect to defendant's request for an instruction or addition of an additional section to the witness credibility instruction regarding Detective O'Driscoll having had an opportunity to listen to all the prior testimony, and that instructing the jury that they may consider whether that opportunity to hear prior testimony enabled him to tailor his account when determining his credibility. The court has re-reviewed Portuondo versus Agard, 529 U.S. 61, U.S. Supreme Court from 2000. That case stands for the proposition that it is not improper for defense counsel to make that exact argument during its closing. But it does not stand for the proposition that it's appropriate for the court to give that instruction as if it is a precept of law.
Ma'am.
So the defendant's request for a jury instruction to that effect
Denied.
is respectfully denied, notwithstanding the fact that you'll be free to make that argument. Anything further?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Okay. Then let's
So it doesn't stand for the
look
proposition that...
at the first two pages.
So she cited him to case law, and the case law says defense can make this argument, but you don't get a jury instruction on it. You don't get a jury instruction that the judge reads saying it's improper for the investigating officer to sit at counsel, to sit in the courtroom during the hearings. She's like, I tried. We tried. And this is why courts take a break to go read the case law, because it matters. And he's like, that is not what this case stands for. Moving on.
Of the additional instructions that I sent out, page 1 is a proposed instruction called informant. It comes from the 10th Circuit pattern instructions. Page 2 is a instruction titled immunity. It comes from the 10th Circuit pattern instructions. I propose that we use these two pages in
Instead
this
of the
form,
snitch
which are
instruction?
not specific to any individual,
Okay.
and use the pronoun they,
No objection.
in place of
The other one, the snitch instruction.
Muji second, CR 415, which is the custody informant. Mr. Burmester.
The state objects to, number one, informant, because there were no informants in this case.
Well, tell me why Carmen Lauber doesn't fit squarely within the first
Because she's a recipient witness?
sentence of this instruction.
Well, what's the first sentence?
The reason
Someone
she
read us the
is
sentence? Damn it. She's a recipient witness, not an
providing
informant.
evidence, arguably, for a defense might argue, is because she was given immunity, which is why I don't object to number two.
Didn't she also indicate in her interviews, though, that she was doing it based upon her sense of personal accountability for having been involved in this situation?
Yes, but that doesn't make her an informant. She testified, both she and Crozier testified to the events they saw. Frequently, in many prosecutions, the government has to make a choice of who to charge and what to charge. And sometimes in order to proceed on one prosecution, you got to give up another one. And that's what we have here, is in order to bring to bear what the government saw as the more serious crime, that is what the state believes is a murder, we had to have those eyewitnesses be able to testify. In order to do that, we had to provide them immunity. I don't think that makes them a fortiori an informant. An informant.
Draw the distinction for me. What would you see the
Burmester, we love the a fortiori argument. And I understand where Burmester's argument is, that these are percipient witnesses, not informants. This isn't someone who was sent undercover to go do a drug buy for the purpose of then testifying about it. They weren't sent in by law enforcement to be an undercover confidential informant. They weren't working with the police before the crime happened. And they weren't in custody with Kouri Richins getting information from her and then turning it over to police to trade on that information, like we saw in the Adelson case. They are percipient witnesses who happened to be in custody when they were spoken to by law enforcement. So different than someone sent in to get information or someone who gets information in custody. I see where his distinction is with that. And I absolutely understand where the argument is. I'm curious to see what the court does. I think the court will probably give it to the defense. That's what the judge has done consistently. But I'm interested to see. So.
informant as being?
I believe an informant is someone who is privy to some statements or some other source that's not directly involved in the crime. So, a cellie who overhears something that a witness or the suspect say.
Like Adelson.
They don't know anything about the case other than what they've heard somebody say in the jail or at a drug deal or whatever. So and I think that recent experience over the last decade or so, I think the courts were very concerned with that type of testimony for obvious reasons.
Let me spin a hypothetical here related to the facts of this case, but not from the facts of this case, to make sure I understand your position. So it sounds like if somebody heard Kouri, or somebody came to law enforcement and said, I have information that might be relevant to the Kouri Richins case, but if I give it to you, I need a break on my probation. And they work out some
Ding,
kind
ding, ding.
of deal.
Like Adelson.
And then they relate that Kouri Richins, once upon a time in 2022, in January 2022, asked me for fentanyl. And I'm willing to testify to that effect. But
Or I
if
heard
do that,
Kouri
is
saying-
that the kind of situation you're referring to?
If we alter that just a little bit,
He's talking about in custody informants.
the defendant, whoever it is, told me something, that they killed somebody, or
Right.
they shot the gun, or
Yeah.
whatever. That
They
I think
shot the
is different.
sheriff.
That's not
But they didn't shoot the deputy. That's what he's getting to.
a witness to the crime. I think if the witness had said the defendant said they bought drugs, fine. But if the witness is witnessing the event, I think that makes them, that's the distinction that I would draw.
Okay. I understand your position.
An
Ms.
informant
Nestor.
versus a recipient witness.
We have no
I see Burmister's point. I think it's a good point.
objection to the new informant instruction or to the making the immunity instruction just general. We're fine with both of them.
Tell me why you believe an informant instruction is necessary, though. There's no dispute regarding page 2, so we don't need to talk more about that. Mr. Burmister is taking the position that as a matter of law, it's inappropriate to
'Cause
give
she's
an
not an
informant
informant.
instruction because, if I understand him correctly,
She's a recipient
Ms.
witness.
Lauber and Ms. Crozier, in his estimation, simply do not qualify as informants.
Right.
Tell me why you believe they do.
The reason, well, I think they're clearly informants. I don't understand the distinction he's making at all. They're people that gave information and got a deal out of it, whether
I don't believe that you don't understand the distinction, especially given the work that you do. They got immunity more akin to a co-defendant than an informant.
I just have never seen that distinction made in the past. I'm not sure I understand this distinction. But the reason I think
don't
you need
believe
both
that.
is because the immunity instruction only deals with the motivation of the grant of immunity.
Which is
The
exactly what your argument was. Your argument this whole time was that the grant of immunity is why people were modifying their stories, that they were percipient witnesses. So the immunity instruction tells the jury to be cautious of somebody getting immunity because they may have a motivation to lie. Right.
Informant instruction deals with other motivations, such as to get out of drug court, to be able to send texts.
That all
to,
goes with immunity.
Mr. Maynard, instead of having to get, urine tests,
Travel to Nevada.
to make herself feel
Moved to
better because she
Nevada.
feels guilty. All of that is not covered by, and those are all benefits to her from providing information that can cause a reason to be suspicious.
Can't
so I
you-
think they're both necessary.
Can't you add the other benefits into the immunity instruction, though? Granted immunity and other benefits?
That's all.
I understand your position. May I ask a different question? I don't understand the relationship between the first sentence and the last sentence of these two instructions. They seem internally inconsistent. Now, mind you, they are the pattern instructions, and so presumably some committee of 10th Circuit lawyers has come to grips with this, but
He's like, but this is dumb. Right, Your Honor. It's confusing. Like Bloodworth said.
That is the last sentence is dealing with the scenario where they find no other reason to find guilt
Right.
other than this person's testimony.
But isn't that exactly what the second sentence in the first paragraph is talking about?
Yes.
It can be. Oh, I see what you're saying. The second sentence. I was looking at the last sentence. I'm sorry. The testimony of an informant alone. Well, if you believe it beyond a reasonable doubt. That's what they're saying. They're saying that you can't, if there's no other reason for you to find her guilty other than this person's testimony, you need to believe it beyond a reasonable doubt.
Okay.
And that's why
All right.
that's there.
So you'd acknowledge that you wouldn't be able to say, well, you can't convict based upon Carmen Lauber's testimony alone.
No,
You'd
they
have to-
certainly can.
You'd have to add some
Right.
language to that statement.
Correct. Absolutely.
Okay. All right.
Absolutely.
She doesn't agree with
Anything
what the
further,
judge
Ms.
just said.
Nestor?
She heard
No, sir.
something else.
Okay. All right. Counsel, with the benefit of your argument and having had time to consider it during the break, the court finds that based upon its consideration of the evidence that has come in this case, specifically
I see a lot of you are saying that you've lost sound. I would go ahead and refresh because that seems to be a YouTube issue, not a us stream issue. Go ahead and refresh.
regarding people like Carmen Lauber and Robert Crozier, that it is appropriate to give the proposed instruction entitled informant that comes from the 10th Circuit pattern jury instructions.
Really? I agree with Burmester on this one, Your Honor.
Ms. Nestor.
No, sir.
Okay. All right. Counsel, with the benefit of your argument and having had time to consider it during the break, the court finds that based upon its consideration of the evidence that has come in this case, specifically regarding people like Carmen Lauber and Robert Crozier, that it is appropriate to give the proposed instruction entitled informant that comes from the 10th Circuit pattern jury instructions that is indicated on page 1. In addition to the pattern jury instruction from the 10th Circuit titled immunity, which is on page 2 here.
I'm not
based
surprised.
on that ruling, the court will
Because the judge splits the difference in the favor of the defense every single time. He does that every single time. I don't agree. I think Burmester made a really good argument on that. Do I think it'll be the thing that's devastating? No. He's going to err on the side of caution. I don't agree. I think that Burmester is correct, but it is what it is.
not be giving any version of model Utah jury instruction CR 415. Mr. Burmester, any further record there?
No, Your Honor.
Okay.
He's going to protect the record first. I think that it's overly cautious.
Then, if
But
you would
it is
please
what it is.
turn to page 3.
He gets to make those calls and
This
protect
is
the
a
record.
revised other acts instruction. 2 questions. First, in the bulleted list, do we want to add any mention of the defendant may have been involved in civil litigation that she referred to as charges? Or do you want to just leave it alone?
I think you leave it alone.
Ms. Nestor.
I think you
No, I think
leave
you,
that shit
I think
alone.
you cured that when it happened, and I think bringing it up now would just bring
Would highlight it.
unnecessary attention to it.
Agreed.
Any objection to that, Mr. Burmester?
No.
Agreed,
All right.
agreed.
And then, Mr. Burmester, if you look at the 1 to 3rd paragraph, I've added
And it would be
some, though not
inappropriate.
all, of the alternative purpose.
It would be inappropriate for the prosecution to focus on that in any way in closing. So I think bringing it back up, I think there's a lot to focus on in that phone call. Her referencing her sister-in-law's like bringing charges or whatever is a leave it alone. You just don't touch that at all.
This is from Rule 404B. I've added the ones that I think have at least minimal factual foundation in this evidentiary record. Any objections, sir?
No, that was our request.
Okay. Ms.
Well,
Nestor,
that
any
one cut
further
to the
record
prosecution.
No, Your Honor.
But I think that
Okay.
follows the law. But that
Good.
that cuts to the prosecution.
Okay, turn to page 4. This is the aggravated murder instruction. I collapsed. Oh, I got to change the numbering. I'm sorry. This is why we go through these things together.
Yes, it is. Yes, it is why you go through them
Bear with me
together.
for a moment. The elements are 1, Kouri Richins. 2, intentionally or knowingly cause the death of Eric Richins. I collapsed that for a reason you'll see in a moment when we get to the attempted instruction.
Okay.
3,
Is it to mirror
under
it?
one or more of the following circumstances. And then in the second to last paragraph, instead of element 4, it'll say element 3. Any objection, Mr. Burmester?
No, Your Honor.
Ms. Nestor?
Nothing additional, Your Honor.
Okay. Then if you turn the page, I needed to put the modifier attempted to before intentionally or knowingly caused the death of Eric Richins to make it clear, Ms. Nestor, that you don't have to intentionally or knowingly attempt. You have to attempt to cause.
Yes,
Okay.
I believe that's right.
And so that's why we switched those around.
That's better.
Any objection, Mr. Burmester?
No, Your Honor.
Makes
Okay.
sense.
There's italics on the last couple paragraphs. Is that for a purpose or?
You know, it was supposed to be beyond. No, that's
Sigma
a-
Grunt in the chat asked, WTF, where's the fraud? The fraud charge here is the forgery. The forgery signing is what they've charged as the fraud, and then the insurance counts are what they charged on the obtaining the insurance policies by false means. They're going to have to go through, I agree with you, they're going to have to go through those elements in closing and explain to the jury how they're getting there. Because they went through that evidence, made sense to me because I've done all the pretrial stuff in this case. So I could see where they were going, but they did not connect the dots while they were making their case in chief for the jury about the insurance policies. And that's what closing is for, to go through the elements and say, here, 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 here. So I think the jury is probably like, wait, what? Wait, huh? I agree. They're going to need to connect those dots in closing. I think the pieces are there. I just don't think the pieces for the puzzle are in order yet.
That is something I just need to edit to match the original. I know what you're going to say. Say circumstance or circumstance is on page
Yes,
5.
Judge is now just teasing the chat with his
Also, I just caught by looking at that on page 4, the one before, it should say
With his
listed in
parlance
element
today.
3.
Correct. I made that
Did you catch that?
interlineation. I did.
Okay, perfect.
Thank you.
Yep.
All right. If you would turn to page 6,
Okay.
elements of insurance fraud, count 3. Ms. Nestor, I understand defendant's argument. Based upon the plain language of the statute under which count 3 is charged, I think elements 1, 2, 3, and 4 are correct as a matter of law as applied to the evidentiary record in this case. Defendant's request for additional elements language is respectfully denied. Any further record there?
No.
But I think it is important to instruct the jury explicitly about what act the state alleges or believes Kouri Richins performed or committed to
I'll come back to this one.
commit this
Starting.
crime.
I thought he was going to pause.
This is a
He did not pause.
starting point, a proposal. I'm not the state's lawyer. I just put something in there to get the conversation started.
Do you want something in there that's more clear? How many indictments? Darlene in the chat asked, how many other indictments does she have?
So
The other,
I'll let them talk first because I'm interested.
she has
in
one
what
other
they say.
case, and I think there are 27 charges in the financial fraud case. I talked about it yesterday. But I think it's 27 charges in the financial crimes case that's following this one. So yes, one other indictment, but quite a lot of other charges. Let me just double check. Where is it? I think, was I right at 27? Now I just want to know if I was right or not. And no, I was not. 26. Chat is once again correct. Chat is bay. 26.
Other than Richins,
Yep, got it.
I was in a
spelling,
6-7 situation.
I think that's what we're going to argue is what happened.
Okay.
So, and this may be more just for Ms. Lewis's benefit, who's listening in, because she'll be doing the closing, but
What? That's a reveal. I did not expect that at all. I am surprised. I was going to take a poll tomorrow, but they've spoiled it. Chad, are you surprised by that? I'm surprised that Lewis is doing the closing. I don't think that's a good choice at all. I'm real surprised by that. Damn. I'm really surprised that Lewis is doing the closing. Do you think they're going to change their mind? Like, I don't necessarily believe that they're going to stick to that. I'm not convinced they don't show up on Monday and go, oh no, I'm going to do the closing. Because they don't have to stick with their representations. And I don't necessarily trust what the defense represents at this point based on what we've seen. Interesting. I had to rewind it. I wanted to hear her say it again.
So I'll let them talk first because I'm interested to hear what they say.
Other than Richins'
got it.
spelling, I think that's what we're going to argue is what happened.
Okay.
So, and this may be more just for Ms. Lewis's benefit who's listening in because she'll be doing the closing, but I am unclear why submitting the application or making the claim or receiving the money
This is the insurance cases.
Fraudulent.
Because
She
in the
knows
state's
he was
theory,
murdered.
and what I understand they are intending to prove beyond a reasonable doubt, is that the application was fraudulent and therefore was void ab initio.
Because of the forged name?
Because of the forged signature from Eric Richins.
So in other words, the crime is getting someone some life insurance they didn't want, because they both applied. You know, she applied for herself and him.
Well, I think what the state's going to show is that she submitted an application that she forged the decedent's signature, listed herself as the beneficiary after he died, as submitted for the claim, took the claim. Now, count 5.
And this is after he had already moved all of his beneficiaries away from her. He had already moved everything into his trust. So if she knew about the trust, which the defense wants to argue, then she's trying to get around the trust. And if she didn't know about the trust, then she's adding herself as a beneficiary without telling him, maybe to try to get the payback the $250,000 or without talking to him. But it's an interesting argument because if they're going to argue she knew about the trust, then she's trying to add herself as beneficiaries to more stuff that she didn't have permission to do. Okay.
If is the signing, right?
Right.
Count 3 is the devising of the scheme to get the money by signing, submitting, making the claim.
So my concern...
Do I have that right, Mr. Permister?
Yeah, sure. It's just
Go ahead.
like frequently there is when you have a forgery, there's a corresponding count, like a theft or theft by deception, whatever.
So the only issue I have some issues with that, but the testimony of the True Stage lady, I'm so sorry, I cannot remember her name. I don't mean to be disrespectful. I just cannot remember her name at the moment. Maybe Coates. It might have been Ms. Coates. I'm not positive.
Sand coats.
Okay, good. Ms. Coates. Was that they did not ever investigate or follow up. When they would get an application, they didn't call the person and say, is this your signature? Is this okay with you?
This is an argument.
That was not something that mattered to them. So we know that Kouri had a right to apply for the policy for herself. clearly, which she did on that policy. She applied for both of them. It was in both their name, like each other is the beneficiary. So they each were getting a policy.
Right.
So.
I mean, I'm saying right. When I say right, I'm saying I understand what you're saying.
Yeah,
I'm
right.
not making a finding.
Correct. So I
The
don't.
court is like, when I use the word right, I'm letting you know that I am tracking, not that I am agreeing that you are in fact correct. That is the most like human meets judge on the bench moment. He's like, no. By correct, I mean, by right, I mean, I'm tracking. I'm not finding that you're actually correct.
Understand how.
Oh boy.
If the claim on the death is based on a death that actually happened and it's a policy they agreed to approve. Once they approved the policy, they approved it. So whether or not.
But if it was obtained by fraudulent means and they didn't know, that's the fraud. How are we not tracking on how fraud works? It's false pretenses. Oh, but they approved it. Doodly-doo, that undoes it. No.
I think the state's theory is there was a threshold intentional misrepresentation in the beginning. That is that Eric Richins signed this with the intent that Kouri Richins would be a beneficiary on this policy. And the state's theory is that simply just never happened.
You can purchase insurance and put yourself as a beneficiary on behalf of someone. Like I could right now get life insurance on my husband where I'm the beneficiary.
Yeah, but you can't forge his signature on it.
Well, if she had authority to sign his signature.
But that's a big if. That's in factual disputes.
That's
in
the
this
point.
case.
That's the
We're
dispute.
just talking about legal elements here.
This is argument, not jury instructions, ma'am.
Sounds like this will figure prominently in defendant's closing argument.
Yeah, I guess so. Okay.
Mr. Burmester, any, besides the spelling error, any...
Wait, before we go on, can I just get a clarification? So I can argue. I'm just concerned.
Do you notice how she just said, I can argue? Lewis is doing closing, but I can argue. I don't know if they're going to stick to what they said here, but I can argue. Notice? She said that a couple times today. A couple times she said today, I can argue. Ms. Lewis is doing the closing. I don't believe that.
Mr. Burmester, any, besides the spelling error, any...
Wait, before we go on, can I just get a clarification? So I can argue. I'm just concerned that if this language is in this instruction, that I'm not going to be able to get up there and argue. This may be their theory, but we don't think any of this is a crime.
You can say exactly that.
Okay, just making sure.
You can say the state
Who's doing closing, ma'am?
had this theory and didn't prove any of it.
Okay. And it does start with the state's theory.
Right.
Why are you asking for
I
him
just
to
feel
hold
like
your
you're
hand through closing arguments? You're not new to lawyering. But Your Honor, can I argue this? But Your Honor, can I argue that? But Your Honor, what do you think of this argument? You're not here to brainstorm.
Telling them in an instruction that that's a crime. That's what's bothering me, right? It's like it sounds like the judge is telling them this is a crime.
No, well, I think this is it.
Identity theft is not a joke, Jim. Ma'am, Your Honor, it sounds like the jury instructions are saying that the crime things are a crime. Why are you instructing them on crimes, Your Honor? Ma'am, crime shaped.
In my mind, you tell me if there's a more artful way to do it in your
Right.
view. There are times in sexual assault cases, for example, where multiple touchings happen of different body parts, and you've got to be real specific in the counts The state's theory regarding count 2 is touching of this body part on this day. State's theory regarding count 3 is touching of this body part on that day to prevent any ambiguity regarding unanimity. Here, we're doing it for a different purpose, but we're providing specificity regarding the state's theory so that it's clear the state is asserting that she did something other than think.
Well, can we put what our theory is? I mean,
That's what argument's for, ma'am.
I just don't.
But you don't have.
The judge already ruled on this. Why are we circling back to the fucking beginning? He asked, anything more on the record? Everyone agreed there was nothing more. They took a break. And now we're back. And she's like, I'd like to reopen this argument. This is argument. We're just going through the jury instructions.
Any burden.
No.
It's annoying.
Other than think.
Well, can we put what our theory is? I mean, I just don't.
But you don't have any burden.
Bing.
No, but we are entitled to theory of defense instructions. I mean,
So argue.
If you're going to put their theory in, I just think adding that part on the bottom is problematic for a lot of reasons. I think just like with all the other instructions, they can stand up and say what they think meets these 4 elements any way they want. But if it comes from you, it's like you're saying this is sufficient.
I can take it out if you want.
That's what I would like.
Okay.
Okay, perfect.
Mr.
Right.
Burmester, any objection?
No.
Okay.
And the prosecution is like, please stop fighting. Please stop fighting. Please stop fighting. The prosecution has been so accommodating. And the judge is like, everybody's just like, we're going to stop fighting. And the prosecution's like, fine. The prosecution has acquiesced so much in this case. Because again, is it really going to change much? Probably not. But it's just so petulant.
I imagine they're going to hear the same thing or something similar in closing, so we'll end up in the same place.
Except now we're back in the position where
She's like, I've
they
won.
can convict
No,
her
you
for just
haven't.
thought.
Well, we were probably in that position.
That's why you added the language in. She's like, oh, well, now if we take it out, now here's the other problem. Right. That's why it was added in the first place, because you were angry that it wasn't there.
Closing, so we'll end up in the same place.
Except now we're back in the position where they could convict her for just thought.
Well, we were probably in that position by virtue of the Utah legislature when we walked in here today. So
Right.
I don't know that we're going to fix that in this case.
I mean, there's evidence that whether they believe it or not is another question, but there's evidence that Kouri Richins filled out an application for insurance, submitted it to the insurance company, and they eventually paid it out.
I don't disagree.
So
whether it rises to the level of a showing beyond a reasonable doubt of the elements of this crime, the jury will determine.
absolutely. And I think the only thing that did to help, I mean, because we're not arguing that a bad thought came into her head. That won't be argued. But it does help.
No. The intrusive thoughts were not about the insurance. She thought she was going to get away with that like dead ass. Stealing money is not something Kouri was worried about. Kouri was real confident that she could get away with that shit. The intrusive thoughts came when she started talking to Mr. Hayden Jeffs and Carmen Lauber. That's when the real intrusive thoughts began.
Help us distinguish unanimity between 3 and 4.
What?
That's the
Well,
one.
I think also the dates.
The
do
dates
that
are
for you.
different.
Yeah.
Absolutely.
But what if we did this?
Yeah.
Just to create an actus reus, because I don't think one exists in this instruction. What if it says intentionally, knowingly, or recklessly devised and enacted
No.
a scheme or artifice?
No.
You got to talk to Mr.
No, you don't get to start adding things into the legal statute. Go take it up with the legislature and complain to them. Tell them to write better fraud laws. No.
Burmester about that. I can't unilaterally add an element that doesn't exist in the statute.
Ding.
Oh, I see what you're saying.
Now, you can stipulate to that if you want to create some appellate insurance, but I also take Mr. Burmester's point seriously.
You're going to create an appellate issue by adding shit in.
Appellate or constitutional litigator, but given the evidentiary foundation and the arguments that would be made at closing, I'm not sure we actually have a constitutional problem here.
Okay, well, I guess I would just have a general objection that there's no actus reus in this instruction, but I think the bottom paragraph adds more problems than it creates, and I would ask that that be stricken, but I understand, I guess what he's saying is, don't worry, I'm going to argue it correctly, even though it's not written correctly on this instruction.
Or I think what he's saying is, even if the statute is somehow defective for not having an actus reus defined,
right,
the evidentiary foundation and the state's closing argument will make it clear that they are alleging
that she has
that there
to do
were
something.
Acts committed here.
Okay.
Is that fairly stated, Mr.
Yes.
Burmester?
We are definitely not making the argument that
she
somehow
just
the
thought about
instruction
it.
is improper or unlawful.
Okay. Okay. And then
She signed it. She sent it in. She had numerous conversations with the insurance company, making sure she was going to get her money. She was just full, hey, dirty, baby, you got my money, got your money. Said, hey, there's no insinuation that she just thought about life insurance and then $100,000 blipped itself into her bank account. No one is arguing that.
else on count 3, Ms. Nestor?
No, sir.
Mr. Burmester?
No.
All right. And then count 5 is just the skinny down version of element 4.
Did we skip? Because on count 4,
I didn't make any changes.
You left it the same. Got it.
There were no objections to count 4.
Wait. I thought count 4 was the one.
We were
Did I
so
miss some? I
close.
apologize.
Yeah.
Let me take a look.
Let me check.
We were so close.
I don't have any handwriting on count 4.
He's like, I didn't
Just
touch
a
it.
moment.
No, she thought you were talking about count 4 when you were talking about count 3.
let's
That's
see.
the problem.
There's one. Just a sec. 2.
Lisa asked,
Mine
is
is
this a
clean
rerun
as
of
well.
earlier? No. We're going through
1
the
and 2.
jury instructions.
Just
We're
a moment,
behind real
Ryan,
time
I'm so
because
sorry.
we chat. Well, I chat. Well, chats. And I didn't put
Count
them
4 was the one about the fees.
1.25.
Wasn't that count 4?
No, that
Or
was
was that
count
count
3.
Count 3 was the language from
That-
the statute
that had the
regarding
fees.
fees for services.
You're right, then no, there was nothing on 4. I apologize, Your Honor.
Okay. Take a look at count 5 for me. Let me know if you have any concerns.
Not from the defense.
Great.
Yep, no objections.
Okay, great.
Are we done? I think we're almost done.
All right. I think that only. Oh no! Here, before we get to
No!
spoliation, Ms. Nestor, my apologies. Any? Did I
Spoliation.
hand out the
I had forgotten about
special verdict
spoliation.
forms? Did I bring them with me?
Then did you, the all amended ones? I don't think we have amended ones.
My apologies. I'll be right back.
No worries.
And out goes the court. All right, we're going to zoom till the judge gets back. This is why we leave ourselves the zoom room for the judge to go grab stuff off the printer. He's like, did I give them to you? No, damn it. They're on the printer in the office. Well, come on back. Come on back, Your Honor. The judge is like,
Counsel,
let's.
we're back on the record.
There we
I've
go.
just handed you a revised version of the verdict form.
Yeah.
If you would just read through it and make sure I didn't miss anything.
If these get filed on the docket, I will make sure the law nerds, y'all, have access to them so you can follow along on Monday. If they don't get filed on the docket, well then they don't get filed on the docket or filed on the docket, and we won't have them. But if we do, I will make sure that you guys have access to them. I think that is the judge clicky-clacking his pen. I mean, I guess it could be Nestor, but I think it might be the judge. Ex-Coco in the chat said, are they closing Monday? Yes, they are closing Monday. It's why they're doing jury instructions today. I'm going to put this at 1.25 while they're flipping pages. We've used our Zoom room. So.
No objections.
Great.
No objections.
Very
Great.
good. Okay. Ms. Nestor, I have a list of practical things I need to talk about.
Okay, then we're going to talk about spoliation. Zoe Hughes in the chat said, did EDB say yesterday there are only 8 jurors, 8 deliberating jurors for this case in Utah? They have 12 seated, so they have 8 plus alternates. So only 8 will deliberate.
But did you want to talk any more about spoliation sitting here today?
Yes.
Go ahead.
Okay.
Your Honor.
Spoliation is an argument regarding destruction of evidence.
May I remain seated?
Yes.
Thank you. So the court has heard in the trial that the night or the early morning that Eric Richins was discovered deceased in the bed, there was a long expired pill bottle directly next to him on the nightstand.
Chat clocked it. Chat clocked that it was about the pill bottle. All of chat was like, it's about the pill bottle. Chat, you are correct.
The picture of the pill bottle has been introduced as evidence. I believe it's 1-8. I'm not 1,000% positive of that, but I think that's what the exhibit number is. If you look at the picture, you can see there is detritus or whatever the word is.
Detritus.
Residue. I'll use an easier word.
Dust.
Residue, dust at the bottom of the pill bottle. There was
The pill bottle was in a
video
drawer.
or pictures that came into evidence of one of the first responders, Mr. Cernich, taking the pill bottle off the nightstand, and then there was subsequently a photograph that was taken, I think it was by Officer Pimentel, but I'm not 1,000% sure about that either, but one of the officers with gloves on holding the pill bottle took a photograph of it. That pill bottle, there was testimony.
It's got to be the judge clicking his pen. I don't think it's Burmester. I think the judge is just like, I think it's the judge.
Was sent with the body to the
In the body bag, right?
I believe so.
To the office of the medical examiner?
I believe that is correct. And that it was delivered to the medical examiner's office. The final witness of the trial, Officer O'Driscoll, was asked if they were able to, or still had the pill bottle, and his answer was that they no longer had the pill bottle.
It was not clear because you objected, but it seems like the medical examiner's office might have gotten rid of it. But it was objected to, and so an answer never came into evidence regarding the pill bottle because you objected to hearsay. So that's not in evidence. So he said the ME's office had it, and I think the woman from the ME's office said, I think we should still have it.
I don't think
Did
that
Detective
last.
O'Driscoll say that?
No, it was objected to because it was hearsay.
I don't know
Correct.
whether he knows whether they still have the bottle.
No, he doesn't know.
Right.
But he said that he doesn't have. They don't, like the Summit County Sheriffs don't have it.
They never had it.
Right.
Yeah.
So
Summit County sheriffs never had it in their possession. Emily, just let her argue.
I don't know if he knows what happened to it at the medical examiner's office or not.
Is there any affirmative evidence in the case about whether the medical examiner's office still has the bottle?
No,
They're not that bottle, no.
Okay.
no.
Meaning no affirmative evidence, or they don't have that bottle?
No,
No.
there was no evidence about whether or not they had it because the ME investigator testified that it should still be at the ME's office, but did not say, yes, I went and checked it out yesterday, because the defense asked in cross-examination. So you could just go get it. And the investigator from the ME's office said, should be able to. That's what they said.
Affirmative evidence of this.
I want the party's
Is
answer.
there any affirmative evidence in the case about whether the medical examiner's office still has the bottle?
No,
Not that bottle, no.
Okay.
no.
Meaning no affirmative evidence, or they don't have that bottle?
No affirmative
No
evidence.
affirmative evidence of this bottle.
No affirmative
being present
evidence.
or not present.
Correct.
That's my recollection.
That's exactly how the
I
evidence came in.
have not rewatched every day of
I
that
have.
testimony from the medical examiner.
Well, I do know that the young woman
I love that the judge said medical examiners. Zzz. I feel so vindicated that everyone remembers it the way that I do, except for Nestor. I feel like that means I'm correct.
and I apologize, I cannot remember her name either. I'm just blanking right now.
Dr. Ulmer?
No. The
Ms.
lady
Gibson?
who checked
Ms.
in the
Gibson.
body that
Oh.
had the tag, the red
Yeah.
tag on it.
Right.
She
Gibson.
testified that what happens is when they open the body bag, that there are their personal effects and the prescriptions that were on scene for purposes of their giving them ideas what to test for, I guess, when they do the toxicology. I assume that's why that's done. I don't know for sure.
You could have asked that
So I
question,
know
but
that
you
she
didn't.
Did. My recollection is that she testified it arrived at their office with his
Correct.
personal items.
Correct. And was kept by
I don't
them.
know that we've ever had any testimony to why it was lost or destroyed.
They
or
didn't
what
say that it
happened to
was.
It's clearly it's gone because it'd have been here if it wasn't.
They didn't say that it
So-
was.
Well, but, yeah, I mean, let's come back to spoliation, right? You have to first show a violation, or that a duty to preserve
Right.
existed.
Exactly.
Then you have to show a violation.
Right.
Then you have to show prejudice.
Right.
So whether or not the duty to preserve existed, they preserved it because it went in the body bag with the body.
Uh-huh.
So
Well-
who is it that you would say violated any duty here?
Well, it wasn't preserved for purposes of the defense to be able to examine it or to use it at trial because it was gone by the time we did our physical evidence examination. It wasn't there anymore.
I don't know that any evidence of that is.
Ma'am, did you go to the ME's office? Because it's not in evidence lockup at the sheriff's. It's at the ME's office. Did you go to the ME's office? Because everyone at the ME's office said it should still be there, including the ME investigator. And you asked about it on cross.
For purposes of the defense to be able to examine it or to use it at trial because it was gone by the time we did our physical evidence examination. It wasn't there anymore.
I don't know that any evidence of that is in the record.
Well, we can do affidavit. I mean, we can do affidavits as to that.
The evidentiary record for trial is closed.
Right.
No, for your evaluation purpose for the. I mean, it's not. I don't think your finding is based on what happened in trial.
No, but
I mean, because
I mean,
all
the-
the time.
I would be stunned if their physical evidence evaluation included the ME's office, not just the sheriff's evidence locker. I would be very surprised if it included both. Because she has not said once that she went to the ME's office. And I bet she didn't.
the evidence is closed. Closings are happening Monday. To the extent you were a party, wanted to make an additional evidentiary showing and have the court make findings sufficient
Too late.
to
Too late to apologize.
support a ruling that there was a breach of the duty to preserve, findings regarding the level of culpability, whether it was inadvertent or intentional,
Right.
and what the prejudice is. That time was months and months ago.
No, I disagree with that. So, I mean, we could, like, even now, file a motion to dismiss under Tiedemann based on what came out at trial, plus additional evidence for the court to consider. We're not doing
This
that.
is not bad.
No, we're not doing that.
Oh,
But
the
I'm
judge started
saying
laughing.
that
If you're watching in the background, if you're listening in the background, come on back. The judge starts laughing. Before they pan away from him, the judge actually starts laughing.
Prejudice is that time was months and months ago.
No, I disagree with that. So, I mean, we could, like, even now, file a motion to dismiss under Tiedemann based on what came out at trial, plus additional evidence for the court to consider. We're not doing that.
This is not that.
No, we're not doing that. But I'm saying that if we're asking for a remedy, that there was a duty to preserve under Rule 16 of this hydrocodone bottle. The hydrocodone bottle, by the time the defense team did our analysis of the physical evidence, it was missing. It was gone. So we've never had the opportunity to test it, submit it to a expert, or have it or use it at all.
Then you should have filed it when you did your physical evidence examination instead of springing it up at trial. No one can say this defense team has not litigated every aspect of this case, though. I know we don't all like the style by which they do it, but there is no argument that they are not litigating every single blade of grass that they can grasp. It is. There's no argument that they're not going to litigate every angle.
All right, so
At
it's
all.
missing. There's no question there's a duty to preserve it. I mean, they thought it was important enough to take a picture of it. It was next to the body. There's clearly a duty to preserve.
Are you making an oral motion now?
And I will concede it up front. We certainly don't have any evidence that suggests they intentionally destroyed it. I mean, we've just not come across that.
Did you go to the
in any way.
ME's office?
But there's
Do we know that
definitely
it's
going to be
missing?
some gross negligence here if the main.
Nobody thinks that pill bottle's the main thing. Y'all wouldn't have brought it up if you thought it still existed. Let's be real. Be so for real. Y'all are grasping to this pill bottle with both hands because you think it's gone. Or your client told you that that's where the stuff from Carmen Lauber got put, and she shook it all up so they would test it. Did your client tell you that she's mad they didn't test it? Because she thought because that's where she put the stuff that she got from Carmen? Is that why we're all so focused on it?
Container of potentially illicit drugs of someone who was found dead of illicit drugs is
If it's a prescription bottle, it's not potentially illicit drugs for the fuck of fuck.
Gross negligence here if the main container of potentially illicit drugs of someone who was found dead of illicit drugs is lost and made not able for us to recover under Rule 16.
You're putting a lot of freight on Maine. There were other bottles recovered in the house, but
Not
keep going.
Not right next to the body. There weren't.
It was
And,
in a drawer.
You know, there was an
It was
unknown.
It was not next to his body. It was in the bedroom. Fuck's
Dust
sake.
on the nightstand right where the pill bottle was could have been part of that. If it was crushed or if it was snorted or whatever it was, I don't know. So the court has a lot of remedy.
Your Honor, my client tried to stage this scene better, and they didn't test it. How dare them? That is what this argument is giving to me. It doesn't mean that I agree, but did you go to the ME's office? Bloodworth asked the question if it was disposed of. So I think that's what opened the can of worms to this. Nobody can say that they didn't litigate.
And how to handle that, right? Like one option is a Tiedemann motion to dismiss. We did not do that. The other option is to say, hey, we would like an instruction to the jury that there was a duty to preserve this evidence. It was not preserved. And because of that, you know, you should assume that it would have been helpful to the defendant. That's the
point of all of this.
Adverse inference instruction under
That's the
Cronish
point.
versus U.S. So, I mean, we're simply asking the court to give us a remedy for the fact that something that was required to be given to us under Rule 16 never was.
Oh, but hold on.
Why is it being brought up now? Because she wants the instruction that's damaging. She wants the instruction that says, if it's gone, you can assume that it's helpful to the other side. She wants the spoliation instruction. without having to prove spoliation. But she wants the spoliation instruction. Why is it coming up now? Because it's too late to do anything about it now. That's why this is being sprung up at the 11th hour. She wants that instruction.
Adverse inference instruction under Cronish versus U.S. So, I mean, we're simply asking the court to give us a remedy for the fact that something that was required to be given to us under Rule 16 never was.
Well, but hold on.
Yeah.
You don't have any evidence that the medical examiner's office kept it long enough for the investigators to get custody of it. That may have been destroyed pursuant to normal destruction protocols of the ME's office, along with the body.
Yeah.
They don't keep everything forever. I need more here.
Right.
Kouri wasn't arrested for over a year. So this was just a death investigation for over a year.
Understand that this is a good faith argument, but spoliation requires findings and it is a multi-factor analysis, and I can't skip steps.
Right.
In order to make a ruling as to whether an adverse inference instruction is even appropriate, I got to get through duty and breach and prejudice.
Right.
And we don't have that evidentiary showing.
Well, we definitely have duty. We definitely have that as
Maybe
material.
not.
I think the only thing that's in question is the breach, right? Like,
No.
To what level of culpability was the breach? And
or was it breached at all? I mean, there are things such as...
I don't think there is necessarily a duty at the ME's office if this hasn't... The ME's office came back with an undetermined finding. The ME's office didn't find this as a homicide, and Kouri wasn't arrested for more than a year later. Does the ME's office have an obligation to keep everything that came in with a deceased after they release the deceased's body? Do they have an obligation to keep it beyond that if there is no criminal charges? I don't think that they do.
Based preservation schedules absent, for example, your client certainly knew that the body was taken, right?
And that
she had an opportunity
bottles
to
were
ask,
taken.
what else do you have? Are there any personal effects? What are you going to do with the personal effects? Now, I'm not casting any aspersions. I'm just saying there are other facts that I'd have to consider.
Right. No, I agree. I don't disagree with anything you're saying.
But I want my instruction, Your Honor.
Where
I don't disagree with you, but that instruction would be really helpful for us.
we might have to have, like, if...
And to be clear, you are not limited from making the arguments you just made to me
Right.
to the jury.
Oh, we will.
Where's the bottle?
Right. No, we'll definitely do that. But what I want is the inference that you got to assume it helped us.
That is, I sit here today,
Yeah.
I don't have a sufficient showing to make the findings that would be necessary to give that kind of instruction under my understanding of the law regarding spoliation.
Okay. If we're able to obtain that for you prior to Monday, can we submit that in writing?
I'm certainly not going to be closed minded.
No.
Okay. Thank you, Your Honor. Understood.
I'm not making.
Your Honor, it is time to put your foot down. He's like, if you need to file it, file it. He can't say don't file it. He can't stop the defense from zealously advocating for their client. I do not like the sandbagging strategy. Sandbag till the very end and then spring it on the court. How long are they going to be on the record before we get to closing arguments on Monday with this then? How long is the jury going to be sitting waiting? Will they argue this again on Monday? Because they want that instruction. That instruction is a heavy hand. It's the court telling the jury that they must consider that the pill bottle would be helpful for the defense. But this is absolutely going to be argued again on Monday morning. There's no way to get around that.
Making any predictions one way or the other.
Okay.
Mr. Burmester, anything else on the record today?
Yes, I just wanted to add a requirement that there be a showing of reasonable probability the lost evidence would have been exculpatory.
Right.
I don't know why fentanyl would have to be stored in another opioid package. I mean, the testimony was that it came in envelopes, for example. So I would just add that to the argument.
I understand. Mm-hmm. That is among the reasons I am proceeding with appropriate caution here, given the findings that the court would need to make in any spoliation situation, alleged spoliation situation.
Right.
Ms. Nestel, you've, by proximity, asserted yourself a little bit. Maybe, do you want to talk to Fred for a minute? And I don't know that you have standing to weigh in, but
After you've resolved all of this, I just had a
What?
request.
no problem. I'm happy to hear you out in just a second. Thank you. Okay.
Who's
Anything
that?
further on that issue, Ms. Nestor?
No, Your Honor.
Mr. Burmester?
No, Your Honor.
Okay. All right. Counsel, on my list, any objection to exchanging slide decks related to your closing arguments by sometime on Sunday afternoon
Who's trying to chime in?
or evening?
We actually talked to Mr. Bloodworth about this already, and both sides decided we didn't want to exchange them.
Okay.
So we're good.
Is that your understanding, Mr. Burmester?
I have no understanding of that.
Okay. I'm going to take you at your word on that,
Yeah.
Ms. Nestor. All right.
I'll confirm it again and make sure he hasn't changed his mind. But if he does, what is the time you want us to?
Who doing what now? Who doing what now? We're going to take a poll on Monday about how many objections there will be during closing. Don't worry. We'll absolutely take that poll.
Whatever you all agree to. I just,
We'll do it.
I'm inclined to order it if you folks want it. But if you've agreed to
Yeah,
proceed in a different fashion, that's fine.
We kind of had a conversation about it when we called on 4 o'clock yesterday. And I mean, opening is different because opening, nothing's come into evidence yet. And both sides are very concerned about what's showed to a jury before anything's come in. And we were all very concerned about swapping. We fleshed that out about closing, and we all just are taking the position, we know what's in now. You can put what's in.
Mm-hmm. Sure, ma'am.
And if you want to use some creative little thing that is just for,
Demonstrative purposes.
Argument?
demonstrative purposes, the other side's not going to be able to object to that anyway. So
Understood.
we're fine.
Okay.
I don't necessarily trust that the evidence is not going to be misstated. I do not trust that evidence is not going to be misstated, but they're probably not going to misstate it in their exhibits, right? They're not, the demonstratives aren't the problem. It's the words that will be the issue.
With respect to exhibits,
Talking.
defense exhibits, Brittany has a handle on. She thinks she has all of them.
Great.
The state's exhibits, she's going to need to interact with the state's team to make sure she gets a bunch. And because the number of state's exhibit is so much larger,
Get
and
Brittany
they're
the
of
exhibits.
varying kinds, there may be some back and forth about that while you're all doing your on-reading instructions and closing
Sure.
arguments. And so if, Mr. Burmester, if you can just make sure the state's, whoever's in charge of that for the
Ms.
state is
Steele
present.
was here trying to talk to,
She's back there.
So Brittany's not here this afternoon, but if you can keep your eyes on your email and be present on Monday morning, she'll need your help.
What I have, I can wait till Monday.
If you want me to leave it on her desk for her, I'm happy to do it. Okay.
Also, we've been trying really hard to keep track of what we believe has been admitted, just to have a backup.
Right.
Backup. So if we could just, before the exhibits go back,
Yes.
give us a few minutes to make sure we're all in agreement that that's what should go
I mean, that
back.
happens
and
in every
then,
case.
and we have a list, we're ready to go. It shouldn't take long, but I would ask the chance to review it before it goes back.
It's my expectation that will take longer than a few minutes and
Yeah.
will involve
That'll take a while.
somebody from both sides of the V and Brittany after closing is complete.
Perfect, thank you.
That's going to take a while.
Some of the exhibits are audiovisual files.
They are.
They need to be on a single thumb drive if possible, or as few thumb drives as possible. The court has an air-gapped laptop that the jury can use to view them. We'll just want to make sure that it works.
And we're fine, Ms. Steele, if you want to provide to us on box what the video ones are, so you don't have to do a thumb drive, that's fine. Just let us know where you put it on box, okay?
I think they need the thumb drive for.
The jury does.
The jury, but I don't want you to waste money on us. You can just put it on box.
The county's done that plenty.
Notwithstanding our conversation regarding the 900 pages of Carmen Lauber's interviews, turns out there are a lot more transcripts that were admitted than I recalled. Several that are companions to the audiovisual files. As I understand it, there's no objection to those going back to the jury, correct? Because they're not in court testimony. They were admitted as exhibits.
Right.
They're going back.
Yep.
Correct, Mr. Burmester?
That
Yes.
seems to be correct.
I believe so, but I will check with that. I mean, we were, there weren't too many transcripts. Most of them were redacted transcripts that we had all agreed on, like the.
Understood. They're all portions.
Right.
For
Okay.
example,
Good. I was like, just
there
getting
were some
panicky.
several recorded phone calls.
Right.
All of them have
Right.
Transcripts.
a companion transcript.
We did agree to those.
Okay.
The parties did. But now I'm panicking if there was accidentally some big transcript that slid back past us that we didn't see.
I don't think so. Brittany just wanted to
Nobody's
confirm,
trying
based
to
upon the
slip it
conversation we had
anywhere.
in the record, where I expressed some concern about a particularly lengthy or complete transcript getting undue influence.
Right.
She just wanted to make sure that she
Right.
understood the state of affairs.
No, I
If
think-
it's been admitted as an exhibit, it
goes
goes
back.
to the jury.
Right.
Yeah.
I agree.
Okay. All right. Anything else today, Mr. Burmester?
No.
Ms. Nestor?
I assume since we're doing so good and we're so far ahead of schedule that you're not putting a timer on our closings?
No.
Okay.
Well,
Not
Chad,
putting a timer on the jury either.
Okay.
that answers your question. Emily, what's the time limit for closing? The limit does not exist. Your Honor, since we've been so good and we're so ahead of schedule, ma'am, you told the judge you needed 2 weeks for the defense, so he built in 2 weeks for the defense, and then you went, whoop. So is there a limit to the closing? No. Oh boy. Oh boy.
All right. I'm going to have to do some breathing exercises before I discuss the alternates, but it'll be all right.
Well, y'all wanted to know what the judge does back in chambers. Breathing exercises.
No.
Ms. Nestor?
I assume since we're doing so good and we're so far ahead of schedule that you're not putting a timer on our closings?
No.
Okay.
Not putting a timer on the jury either.
Okay.
All right. I'm going to have to do some breathing exercises before I dismiss the alternates, but it'll be all right.
I know. It's pretty amazing. We haven't lost a juror in
They are
a
a
3-week
hardy
trial.
group. And I'll make clear to them that they're not released.
Yeah.
They're just, they need to abide by all the rules in case somebody falls ill, suffers a tragedy during
They're a
deliberation.
hardy
Right.
group.
All right. I appreciate your time and effort this morning, Ms. Afternoon, Ms. Nestel. Sure.
Who is Miss Nestel? How are there new players?
Happy to listen.
What's happening?
As you know, I represent the victims in this case who are here today. They've been here every day.
Huh? A lot of you are asking who closes first. I believe it's prosecution, defense, prosecution. Massachusetts does it weird. I don't think Utah does. I think it's prosecution, defense, prosecution, but we've only watched a civil case in Utah, and that's how they did it. They did it plaintiff, defendant, plaintiff. So the attorney that represents the victims.
Sure. Happy to listen.
Huh.
As you know, I represent the victims in this case who are here today. They've been here every day filling the row. We have a special request for Monday. I don't know if it'll deviate from the court's decorum order, but if it does, we think it warrants a special decision or order from the court. And that is we're asking for the victim's family to be able to take that second and even third row.
Well, that's a
during the
reasonable
closing
request.
arguments. Of course, nobody could or anticipate when the case was going to close or when closing arguments would be, but that's a really important day. It's an important day for the victims to exercise their right to be present, which to be meaningful means they want to hear and see as much as they can. So I think they've been very abiding to the court's decorum.
That makes sense. Okay, just a little bit of background. The court's decorum order has had alternating rows. I actually have that decorum order somewhere and I can pull it up, but the decorum order has the family's alternating rows. So it's not a problem of who sits closer, who sits farther, where everybody is. So there are alternating rows of the families for the decorum order. So the victim's representative is asking, here, let me see if I can find that. But the victim's representative is asking that the family be able to take the closer rows for closing instead of being in the back row behind the public for closing. And I think that's fair because unlike members of the public who, yes, have an interest in the trial, family being in the courtroom holds greater weight for me than the public who can watch streaming. It's different for the families to be in the room. And there's opportunity for an overflow room, and the overflow room can have the public as well because they can still observe, but the family having space not in the fifth row, the back row of the courtroom, but being closer makes sense to me. And they have abided by the court's decorum order. So I think that's a reasonable request. I'm going to look for this decorum order while the victim representative continues to talk to the court. But okay,
Order. This is.
Back that up from the beginning, but that makes sense.
But that's a really important day. It's an important day for the victims to exercise their right to be present, which to be meaningful means they want to hear and see as much as they can. So I think they've been very abiding to the court's decorum order. This is really important for them. There were a lot of witnesses who were subpoenaed and weren't able to come in, maybe didn't even end up testifying, but they want to come as well. So during the pretrial proceedings, the victim's family had 2 rows that they filled regularly. And there are a lot of people who loved Eric and supported him and who would like to be here that day. And to prevent people from having to camp out all night at the court's doorstep, just to make sure that they get in. Our request would be that they get the second and third row designated.
Chris, have we handed out wristbands for Monday yet?
No, sir. Our plan is to hand them out for order before 0800.
So they're saying they're going to hand out wristbands before 0800. The decorum order right now says that the defendant, counsel of record, and counsel support staff may sit in front of the bar behind the attorney's tables. Spectators must sit behind the bar in the well. The first row of the gallery is reserved for the 10 media representatives, and there is a seating given out to the media pool in advance. So that is done in advance with approval from the court. The second row of the gallery has 12 spots. On odd numbered days, the second row of the gallery shall be reserved for the Richins family. On even numbered days, the second row of the gallery is reserved for the Richins, or Kouri Richins, friends and family. The fifth row of the gallery has 12 spots, and then it alternates. So either the second or fifth row. And then the public has the third and fourth row, limited to 12 spots each row. And the wristbands are allocated first come, first serve every day at 8 a.m. So that is what they're talking about now. And yes, people have been waiting quite early. And I understand for the public, but for the victim's family, it's having to have them wait outside the courtroom to try to get a spot to go to closing arguments. I understand why they want to avoid that. And you get a little bit of a sense of where the operations are for the pool camera right back here on the side.
So I'm just going to sound this out in real time.
I mean, the public can just come watch with us.
What I can't do is change the rules regarding odd and even midstream based upon genuine empathy for one side or the other. But
I can reserve an extra row,
I
though.
can steal some rows back from people that
I think
do
that's
not
fair.
have a familiar connection to the case.
I think that's fair.
And so, Chris, it sounds like I could say rows 2 and 3.
And I think it's fair that the court can't just yeet whatever family member or whatever family would have the alternate. I mean, that also makes sense that you can't just throw out one side or the other on odd or even numbered days. Let's see. What day is Monday? Is Monday the 16th? So even numbered days is Eric's family, odd numbered days is Kouri's family.
3 are going to be for whoever would have gotten row 2 in on whatever odd or even day Monday is, and rows 4 and 5 can be for whomever was going to get it on that day. So I can double the amount of space. I just can't switch.
I think it's fair that the court's like, okay, so whoever gets row 2 can have 2 and 3, and whoever gets row 5 can have 4 and 5, and then the public is kind of, well, out.
Order.
Okay, and I think possibly the defendant's family would have been on Monday. Of course, again, we didn't know the trial was going to end, or that important
I think
day
Monday's
would be
certainly needed
on Monday.
Yeah.
If those rows are not filled,
I don't know if they mean even court days or even calendar days, because Monday would be the 15th day of trial, but the 16th calendar day. Fuck, that is confusing because it doesn't say. It doesn't say court days or calendar days in the order. I never really thought about it.
can those seats be filled?
No, it makes it very hard for court staff to manage who's sitting where and to make sure that everybody is behaving. So I got to have clear rules, but I can double the space. I mean, let's be clear. What I'd be doing is
kicking out
excluding the rest
public.
of the public.
Yeah.
Right.
But let's put it blank. Instead of one row for Miss Kouri Richins' family, 2 rows for the public, 1 row for Eric Richins' family, it would be 1 row for the media, 2 rows for Kouri Richins' family,
and 2 rows for Eric's
guests, and 2 rows for Eric Richins' family and guests.
Okay. Thank you.
Chris,
That makes
now that I
sense.
said that out loud, that's an idea. I got to make sure I did not create any trouble.
I have to deal with the public.
Well, we can send something out, right?
He's like, I have to deal with the public. Chris looks thrilled to deal with the public on this. Excuse me, Your Honor, when you send them a notice, could you just say that every law nerd on the internet is going to be watching it with EDB, and if they get the law nerd app at lawnerd.com, they can just come watch with us? Can we include that in the court's order? Maybe. Worth trying.
I imagine that I could ask our media partners
You could do an overflow
to
room.
help me spread the word. So we'll get to that. Okay.
So I'm happy to talk to Ms. Richins' family and see if they need that second
They're
row.
not going to need 2 rows.
And if they don't, I can communicate with Mr. Palmer and tell him there will be 1 row for the public.
I'm probably just going to make this decision now so there's no ambiguity so we can get ahead of it.
Okay.
So that people aren't coming to the courthouse 2 days from now with an expectation.
Okay.
Set the
Will you
expectations.
give me 5 minutes to talk to Chris to make sure I'm
Yes.
not working at cross purposes with the security plan?
Yes.
All right, let me take a 5-minute break, folks. Thank you.
All right.
That's incredibly mindful, Your Honor. That's incredibly mindful of the security plan. Here's why I like sitting where we're at. Well, 1, my chair's comfier than sitting in court, like for real. But 2, when you are sitting in court, if you have never tried to go and sit in one of these cases. First of all, it's uncomfortable. Second of all, you cannot hear as well. Third, you see the back of everyone's head. I appreciate being able to watch the lawyers' faces and counsel table and the audience. We get a look from almost the judge's vantage point versus the back of everybody's head. And yeah, we get snacks. But the court can probably do an overflow room if they really wanted to. All right, let's zoom. Apparently the court's taking a break. I mean, the public has the right to observe. The public does not necessarily have the right to be in the room where it happens. There is nothing that really says that access to court means they have to sit their butts and breathe the same air. I think that having it streamed is a reasonable accommodation for the public, and I don't have a problem with accommodating those that are most personally impacted by a case. So we'll see what happens. I know. Plus, we can
Things
pause
on Monday.
Plus, we can pause and rewind.
Plan for closings on Monday and the period of jury deliberations.
Oh, the mics came back in after he stopped talking.
Plan for
This is going to be the plan.
closings on Monday and the period of jury deliberations. First row, as usual, will
Media.
be for members of the media with authorization to have a seat in those rows. Whichever family, whether it's Eric Richins' family and guests or Kouri Richins' family and guests, is entitled under the current odd-even switching scheme to the first or to the second row will get the second and third. Whichever family
makes
set of
sense.
guests is entitled to the fifth will get the fifth and fourth. Keep in mind they're going to switch each day.
That's fair.
So if the jury keeps deliberating into Tuesday, it'll be 2 and 3 versus 4 and 5 switches.
I think that's fair.
Mr. Palmer, court security director, will give counsel, defendant's counsel for defendant's family and guests, state's counsel for
Lanyards.
unless you want to be the point person, Ms. Nestel, it's up to you.
That would be better.
Just to take the burden off of them.
All right.
Yeah.
Ms.
That
Nestel,
would be
on
better.
behalf of Eric Richins' family and guests, is going to give you 24 wristbands. And it's up to you who gets them. That'll be per day.
Thank you.
Okay? Means you got to be here, somebody from your team and somebody, Ms. Nestel, you got to be here no later than 8 a.m. each day.
I think that's fair.
All right?
I'll do it.
Very good. We're all going to buy Chris Palmer chocolates and flowers because he's going to take some flack about this. I will issue an
Do not tempt the law nerds to send gifts, Your Honor. You have no idea. You will be inundated with gifts for Chris Palmer.
amended decorum order to make it clear this is the way we're doing things. It's the fair way to do it. To the extent you can include this in your reporting about what's coming on Monday, I'd appreciate it, just so people aren't showing up unnecessarily.
We've told the law nerds. They are
All right.
aware.
Anything else, Ms. Nestel?
I mean, the
Business.
only thing that would be fun about being in court is to have the judge look at you and go, could you please include this in your reporting? Don't worry, Your Honor. We like to be comfy with our snackies. Don't let Kouri give Chris Palmer any sandwiches
Your Honor.
Mr.
or chocolates
Burmester.
No, Your Honor.
or cookies.
Folks, I appreciate your patience.
drinks.
Please travel safe. Ms. Richins, I'll see you Monday morning. Take care. Court's in recess. Thank you. Grace, I think you wanted-
Don't sour lemon face at our judge, Miss Kouri. What are we? What face are you making at our judge, ma'am? Come on. If you're listening in the background, sour lemon face.
Anything else, Ms. Nestel?
Look at this.
Ms. Nestor.
No, Your Honor.
Mr. Burmester.
No, Your Honor.
Folks, I appreciate your patience. Please travel safe. Ms. Richins, I'll see you Monday morning. Take care. Court's in recess. Thank you. Grace, I think you wanted to talk.
And the court's like, Grace, I think you wanted to talk to me. Grace is the producer from Court TV. Court TV's since been purchased, and all of the things. But The judge is like, I'll see you on Monday. I'm sure she's nervous. How could you not be? Shit gets real. Listening to jury instructions gets real. But also, don't make sour faces at the judge. What are we doing? All right, law nerds. So here's my question, chat. Now that we have seen that the defense wants a spoliation instruction and says they're going to file over the weekend a motion that says the destruction of the super duper really, really old prescription bottle that the medical examiner's office took from the Richins' home, that the defense keeps trying to say was next to Eric Richins' body. That's not true. But the defense wants a spoliation instruction saying that any evidence derived from that bottle would benefit the defense. How long do you think we're going to be arguing about that on Monday before they start closing arguments? I'll let you guys answer that. And for those of you in the replay crew, just put it in the bottom. Put it in the bottom. No, Emily, damn it. Today has broken everyone. Put it in the... I'm going to start singing other songs. Put it in the comments. Put it in the comments. Chat's already saying gentle pressure only. Fair. Put it in the comments. But we also learned today, what did we learn today? We saw the arguments over the jury instructions. We learned that the defense is going to be filing motions over spoliation of the super old prescription bottle that they say was found right next to Eric Richins' body, though I don't think that's how that went in the evidence. We heard Miss Nestor say that Miss Lewis was doing closing arguments, and then we heard Miss Nestor say repeatedly, so I could argue this, I could argue that, I could argue this. I don't think I have a beat on who's doing closing for the defense. It was odd to me that she's like, oh, well, Miss Lewis can listen since she's doing closing. And then Miss Nestor's like, so I can argue, I can argue, I can argue. I guess we'll see. Watch them show up on Monday and be like, Your Honor, we'd like to split our closing. We would both like to argue. And there's not going to be a time limit on closing arguments. The limit does not exist. Because of the rule of pretty please, Your Honor, we're so ahead of schedule. And we did find out what the judge does in chambers. It is not yoga. It is not screaming to death metal, though I still think that would be hilarious. Because we heard the judge say, I'm going to need to do breathing exercises before I dismiss the alternates. So we know that the judge himself is a little bit stressed. He might be utterly stressed, but that's a weird word we learned in the charging conference, and it makes Miss Nestor think of a cow. And the judge was just like, moving on. He did not say that. I did. He did say moogie with a very protracted moo later on, and that was funny as hell. So I wonder if on Monday we're going to see that the defense's representation to the court of whose closing was not 100% accurate, that the defense is still going to be arguing over spoliation, that the defense is going to file that motion like at fucking 9 p.m. on Sunday or some shit. And we will see what happens. But what else we learned is that at the very end of the charging conference, the, I think, attorney advocate for the victim's family asked that the Richins family have the ability to have 2 rows of seating in court. Each row they have assigned 12 seats for. So the public does not have seating at closing. The Richins family will get, everybody's the Richins family. Eric's family will get 2 rows. Kouri's family will get 2 rows. Each side will get 24 wristbands, and then they will be able to decide who can be at the courtroom. And then the odd even days of who sits where is going to stay consistent. So I think that we are going to see extended closings. I think they will go over the lunch break. I hope that closings will be done on Monday. It is possible that closings could go into the following day, depending on how long the defense takes. It is very possible that closings bounce over into Tuesday, and it'll be interesting. That becomes an interesting strategy. If the defense argues over the spoliation, and we know the judge tends to not cut them off. If the defense argues in a more protracted way in the morning, and then the prosecution does the first part of their closing, it's possible that we could get to the lunch break before defense starts their closing. And if we get to the lunch break before the defense starts, I think we could see the defense use the rest of the day, and then the prosecution do their rebuttal on Tuesday morning, and then do the final instructions, which generally take about an hour, if not a little bit more, on Tuesday, and then give it to the jury to deliberate on Tuesday. So it's possible that we see closings bump over into Tuesday. And if I was the prosecution, I would be looking at the clock to embiggen my closing to push the defense into the back half of the afternoon so that I could do rebuttal the next day when the jury's fresh. I 100% would do that because the defense has shown that they have been a little bit long-winded, and I would not want to squeeze the rebuttal in on Monday afternoon and hold the jury longer. I would rather let the jury go home a little earlier. So I would also not be speeding up the judge's decision on that spoliation. If the defense is arguing that, I would let them just keep arguing it, and I would try to push their closing to after lunch. And that would be interesting to see. So I think we will see some maybe timing gamesmanship. We know that Prosecutor Bloodworth is probably going to do the closing arguments, and he has some very poignant pauses. And I think it's fair for the prosecution to look at their time and strategize their time and not hasten through their closings. And we saw that with the opening. We saw that the prosecution was well paced in their opening. I think we're also going to see some objections during closing. I don't know if we'll see them during the prosecutor's closing or if we'll see them during the prosecution's rebuttal. But I would be really surprised if we get through the defense closing argument without at least one objection for misstating the evidence. I don't think it's going to be possible after everything we've seen. Now, perhaps the prosecution will let it go, but I would not be, I do not have faith that we will see a closing argument from the defense that does not misstate the way things came in. I would, intentional or not intentional, every time they talk about things, there's just these tweaks of, oh, well, this was said. No, it's not. That's not what was said. It's constant. And I think the prosecution will have to say, objection, Your Honor, facts not in evidence. And there's room between misstating the facts and between making argument. And we saw that most recently, I think most egregiously in the Cardi B case. It was wild. So that's what I expect on Monday. If you don't have the Lawnerd app, now is the time to get the Lawnerd app because A, the Lawnerd app will keep you in the loop on when closing arguments actually start. So if they start arguing over whatever on Monday morning, it's going to take some time before we get into closings. When we get into the prosecution's closing, we will send an app notification. When the defense starts their closing, we'll send an app notification. And of course, we will send app notifications when we are going live during verdict watch. And well, because we're going to be on verdict watch on Monday or Tuesday. And then we'll have those conversations after closing. Just a reminder to all the new law nerds. First of all, welcome. Good to have you. Second of all, I do not poll on verdicts, what the verdicts will be. I do poll on things like whose closing argument did you find more persuasive? We will talk about how long do you think the jury will be deliberating for? and things like that. But I do not poll on ultimate questions because that is for the jury, not for us to decide. I think the judge is already bracing for Monday. The judge knows that this spoliation thing isn't going to go away anytime soon. So we will see. But yes, I can't believe that I'll definitely do a poll about objections. I'll do a poll about objections on Monday. Because, oh boy. The court told the jury to be back Monday at 8:30. I will be close. Promises, Emily. I am anticipating being closer to real time. However, if they are now knowing that they're going to argue the spoliation, we're going to need some Zoom rooms because they are not going to start closing. I think it'll probably be at least an hour before they even are able to bring the jury in to start closing. And we'll need some Zoom room on that, especially since if she continues to argue it, the judge will need some time to review things. So I think we're going to need some Zoom room on Monday. I don't think they're going to start closings within 20 minutes of the jury coming in. I just don't think that's going to happen. And there's initial instructions as well. So we're going to need some time for sure. All right, let's answer some questions. You know what we didn't do? I totally forgot. I said I wasn't going to. I totally forgot to get our miles today. So instead of a question swoop, let's do a questions flight, answer a few questions, and then I'm going to go eat dinner with the fam. Yeah? Sounds good. All right. Let's fly home for the weekend. That is our flight home. Debbie in the chat said EDB, so the state will still close twice, even though there's no need for their rebuttal. The rebuttal close and the rebuttal case are two different things. So even though the defense did not do a case in chief, I guess unless the defense waives closing, which would be unusual. I don't think this defense is going to waive closing. But there's no rebuttal case and no rebuttal witnesses because the defense did not put on a case in chief. But if the defense speaks words in closing, the prosecution gets to do a rebuttal close. And I do not think that Utah does what Massachusetts does, where the prosecution just goes second. So I don't think the defense will waive closing. And in the Gwyneth Paltrow case, they had the split closing in civil, so I imagine they have it in criminal as well. Jojo said, I hate to say, but now think the judge is too indulgent. I think the judge has been cautious, incredibly cautious. So that's, he has continued to be cautious. Debbie in the chat said, will we listen to closings uninterrupted? It depends what happens. I make no promises. It depends what happens. If we need to pause, we'll pause because it depends what happens. Sometimes fuckery pops off, sometimes not. Grace Mary says, what constitutes making impact statements? Victim impact statements don't happen till sentencing. And the legislature in each state sets forth statutes of who constitutes or who counts as a victim to make an impact statement. And impact statements are statements to the court to inform sentencing. And not everyone falls under the statute. If you did not take a look at the Banfield case, the sentencing of Juliana Magalhaes, the defense actually objected to some of the impact statements, and that was sustained. So it has to fall within the definition of victim in the statute in the state, and then it has to be for proper purpose. And each judge has their own kind of line where impact statements can be too much. We also, I think it was Darrell Brooks, where someone was escorted out, but I don't think it was while they were giving an impact statement. I think somebody stood up and yelled. I don't think that was during an impact. It was during the impact statements, but I don't think it was while they were giving their statement, but I don't quite remember. But you can't just scream at the defendant it is meant to be a statement to the court about the impact the case has had on you, not screaming at the defendant. Then again, in the Kohberger case, a lot of the impact statements were directed directly at Brian Kohberger, and Judge H was just like, go on with your bad self. I'm not interrupting at all. Go right ahead. Go right ahead. Go on with yourself. Yeah. Judge H was just like, I'll allow it. Read him up one side and down the other. Go right ahead. And different judges have a different threshold, and different states have different statutes about what's allowed. So it just depends on the judge and the state. So let's see. Sarah said, why do I feel that she's going to bring something questionable in the slides? I think the defense has broken trust in this case. That's not true in every case. But during opening statements, the misstating the pill bottle was a red flag, and then it just got worse. And so the trust is broken there. I don't trust that the defense will do things the way we would expect. Yeah, the way we would expect. I don't have a lot of faith there. The defense has pushed the boundaries of zealous advocacy for me. I would be very frustrated. The prosecution team has been fairly stoically patient. I would be frustrated. But then again, those types of shenanigans are to make you frustrated and to lose sight of your own case. And they haven't fallen into that. Christina Nash 12 said, shout out to Adriana Kincaid. Wait, it disappeared too fast. For absolutely crushing her law school midterms this past week. When she's not studying, she's listening to EDB. Hashtag Lawnerd. Congratulations on your midterms. And I think that this also counts as studying, because you can yell, no, that's leading at the TV. That counts. I think that counts. So, yeah. Sweet Steffi said, from EDB TED Talk in 2017 to present. Yes, I still feel the same way I did in my TEDx talk. I've grown a lot since then, but I still feel the same, that we need to use the time that we have the best way that we can. And I appreciate earlier in stream how many of you were so just incredibly kind about everything just hitting me in the feels. Cali Girl 224 said, EDB, I'm class of 96. Also have a senior. Everything hits in the feels, right? It's just like, it just hits in the feels. It does. Ugh. I mean, EA Plant said, I have a senior is the best excuse for all the emotions in the spring. I think so too. It's just like there was college shopping happening this week. I'm just like, I have a senior. It's all of the feels. I have so many feels. Jordy, whoa, I'm going to pronounce that wrong. Jordina, maybe? 9568, my youngest is a senior. I absolutely get the feels. Much love. Thank you. Lawners, you guys are so kind. You guys are so kind to me. Breezy said, my dad's high school marching band teacher was also my marching band teacher. It was amazing. I was blessed. His class was a safe space, as the arts tend to be. I feel very strongly about that. That shocks none of you. Emily, I'm so surprised. Nope, shocks none of you. And I do really love theater. I just don't love this much theater in court, right? I'm all for, Chicago on Broadway. I'm not for it playing out always in the courtroom in that way. There is an art to it, and people try to be artful in it. My cord got stuck. There is an art to it in court, and some attorneys balance that well. Some not so much. I think Ramos actually had the best redemption arc of the trial. It was like that wild first cross, and then a good cross, and then he just got sat at the end of the table. I was like, wait, bring back Ramos. bring him back. I know, I was sad at the end. At the end, I was just like, the first one was just, but then it got better. It got better. And I liked that it got better. I was hoping for more better. Nope. Enchilada Mama said, I just want Bloodworth to wear a black suit with a purple tie for closing arguments. Solidify the vampire, Lawnard, please. Look, a lot of attorneys have a closing argument outfit. I do not want anyone to change the good mojo that goes with the closing argument outfit. There is superstition to quite a lot of that. So I will make no requests because you don't mess with the mojo. You don't mess with the mojo. It's law is a lot like sports. And you do not mess with the mojo. So we'll see what happens at closing. But you gotta kind of stick to the vibe. And I would imagine most attorneys have a closing tie. I had a closing outfit. Did Georgia Kappelman wear the same outfit in closing for most of the cases she prosecuted? I'm curious. But some of you are like, did Emily have I did have a closing outfit. We'll talk about it another time. I can promise you it was not a white suit with hair clips. It was not that. It was not that. So I'm going to answer a few more questions as best I can. I see your super chats. I know I won't get to all of them because some of them are comments. I try to get to the questions. I mean, this is true. We are. Look, the chat is well hydrated. Being thirsty reminds us that we need to hydrate. That's all. That's all. We need to remind ourselves to hydrate. A lot of you said same color for Georgia. Yes. That makes sense. Let's see. And the jury was off today, so they got to relax. Can you imagine Judge Everett here? Oh, I'm not talking just to talk, counsel. I can imagine it. Because I can imagine Judge Everett getting frustrated a little bit frustrated. So let's see. Rebecca wants to know, says, I need pictures of EDB and high school band. I know we went over them in a members only. I just don't remember which one. We did that at some point. I just don't remember which. Komizoa said, Gen Z stare. EDB, thank you. You continue to remain strong and focused in covering law. I mean, focused, I appreciate you. Might be a stretch, but I appreciate it. Focused in our own special way over here. But thank you for the compliment and covering law and making the procedure of justice accessible. That is my goal. I want to try to help understand the process from, again, my experience, my perspective, and the way we see it play out in court, because court is a very human thing. The laws are written by humans. This is a very human process. It's a lot of emotions, and court is a very odd collision of emotion and logic. And court often strips out a lot of that emotion because it has to lean into the logic, which feels really unnatural when looking at it. And it does not always comport to the way we see the world. And that is sometimes a really awkward fit. There are reasons for it, but I think having discussions about the reasons and how things work helps understand that juxtaposition, even when it's not natural, because it doesn't always feel natural. And that's why there's so many rules. There are so many rules to court because it is a balance. And it's needed. So, which is why we should do a CLE at some point. I agree. I do not want to be a judge. Cheryl, I appreciate you. It is such a kind compliment. EDB, I want you to be a judge. I do not have the patience of Judge M. I do not have the patience. I do not. Judge M even had to explain, like, my face is neutral, my face is not facing. Literally me all day, every day. Counsel, the fuck? Like, that is not appropriate judicial demeanor. You cannot go, counsel, be so for real right now. Would you like to rethink that? Would you like to take that back? Yeah, that's what I thought. Shh. No, you can't. No. TV judge I would consider. I could judge Judy. I could not real judge. I do not have the judicial demeanor. Also, especially in my jurisdiction, as you start out judging, the cases that you are handling have a lot of paperwork and checkboxes and stuff. The way it would make me crazy to check off all the checkboxes and go through all the amount of paperwork. No. I love doing this. I love doing this. My face could not do that. There's no way my face could do that. I want to see how many other cases kind of spill into this case, because I'm very interested in, we've seen little snippets of other cases play into the defense team here, and I'm curious to see what happens. But I know. I appreciate it. I appreciate the compliments. No. Nope. My patience would be stretched. Also, I really, really like being here with the law nerds. It would be so hard to sit in court and have to go back to just internally processing the commentary and not being able to let my face show it. I did that for a very long time. I do not want to do it anymore. I like doing this with y'all. I think y'all like doing this with me. And we're going to get to do it on Monday and maybe Tuesday and Wednesday as well. So I think that's going to be interesting. I'm looking forward to closings. Closings are my favorite. I love a good closing argument. There have been very few lawyers who have made me hate closing arguments. Lally might have been one of them. I love a good closing argument. Love a closing argument. So I'm very excited to see what happens on Monday. You guys ready for closing? Closing time. I know that all of you are like, I'm not ready for this case to be done. And also, we've been watching this trial for 700 years. I know. I don't know what to do with myself. So let's embiggen closing. Maybe it'll just happen until Tuesday. We'll just keep closing until Tuesday. Let's just do that. It's true. Judges don't get soundboards. Can you imagine the like idiocracy vibes of being in court and just when Miss Nestor starts talking, just survey says it'd be funny. It would not be appropriate. The Judicial Council would not be happy. They would try to vote you off the island. Yeah, it would not be good. But I'm ready. I'm ready for closing. I'm interested to see what happens. Y'all get the Law Nerd app. I'll tell you what happens, but there's no way they're gonna get started without hearing another argument on spoliation. We know that shit's coming in hot on Monday morning, right? 100%. All right, Law Nerds. Chat with each other about what you guys are doing this weekend. Leave it in the comments if you are watching this on replay. I'm curious what y'all are up to this weekend. What are you getting done before we are sat for a full day of court on Monday? You let me know. I think we're actually going to do some gardening tomorrow, and I'm very excited. So, Law Nerds, have a great weekend. Mods, Team Baker, thank you. I know this was a late one. I will see you guys Monday. You ready? You ready for Monday? I am too. I'll see you then, because we're getting close to verdict watch, y'all. It's time for closing. See you Monday. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court and, of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a law nerd.